Inform the other side.
I have not informed. I want to withdraw I have the instruction to withdraw the.
Okay, you inform then, okay? There is a private respondent. He told us.
May it please your lordship. Lordship, I got to mention.
Let us pass the order. He wants to withdraw it. MSS Roy, Learned Counsel for the petitioner, submits that there is instructions to withdraw this writ petition. Full stop. Also heard revenue, anyone? The Hazarika or anybody? Is she there in the court?
Highly informed.
She is there, otherwise. I also heard MS M. Borman, Learned State Council, MSG Hazarika, Learned Revenue Department, Learned Standing Council Revenue, as well as Sri D. Das, Learned Council for the private respondent was 11 to 14. Writ petition accordingly stands dismissed on withdrawal.
May it please your lordship. Lordship, I got to mention for.
Mention in court number 4. In court number 4.
For withdrawal, lordship.
In court number all mention.
Okay.
Mr. Lordship, so I get item number 9, my lord.
Yes.
The matter has become infractious.
Now, 4 is not sitting. Lordship, perhaps court number 4 is not sitting.
Yes. Bench 4 direct 9 again. Huh? First, Amar Dixon.
Lordship.
Okay. What is it?
Lordship, I need to mention for listing of a writ petition for withdrawal, lordship. Can it be
When?
tomorrow, lordship?
Yes.
My lord, one motion matter, lordship, the agency is there, lordship. May I pray, lordship, this matter may be taken up tomorrow, lordship.
Tomorrow, day after tomorrow?
My lord.
What is the matter about?
My lord, regarding election of cooperative societies, lord.
What is the urgency?
My lord, urgency is that election is going to held on 25 plus.
Okay, when is it?
My lord, Friday.
Oh, no, I mean, sorry, Friday, day after tomorrow.
Well, one detention parting from 10th and matter, my lord. The tender is going close to by tomorrow, my lord. 8 is 5 is 12th, my lord. The matter will come up tomorrow, my lord.
Okay.
Mr. Lordship, I get item number 9, my lord. The matter has become infractious.
3 M. Hussain, Learned Counsel for the petitioner submits that by flux of time, the matter has become infructuous. Also heard MSM Borman, Learned State Council, Para. Writ petition accordingly stands dismissed as infructuous.
May it please your lordship. My lord, I am paying for listing matter day after tomorrow.
What is this stage?
Stage lordship, election held, result not declared.
Stage of admission or what?
Motion lordship.
Day after tomorrow, yes.
Day after tomorrow.
Okay, yes.
May I please.
Yeah, please, your lordship. I have to mention item number 35, my lord. Lordship, in this case, we have filed an IA, my lord, which was not taken, my lord.
35. When did you file the IA?
IA 11/4/23, my lord.
Is it numbered?
Yes, my lord. Number 4 to
Okay, bring it. You want to have it today?
today, my lord. Item number 35, my lord.
Okay.
Obliging.
Have you served a copy to the Forest Department?
Yes, my lord.
May I please, your lordship. May I please, your lordship. I beg to mention item number 12, my lord.
Yes.
1 2. My lord, may be taken after 2 weeks, my lord.
Some difficulty?
My lord.
You have some difficulty today or what?
No, my lord, I have to take some instructions, my lord,
Okay.
regarding
On the
payment.
prayer of Sri Y. Rahman,
W. Rahman.
W. Rahman, Learned Counsel for the petitioner. Matter stands adjourned by 2 weeks to enable him to take instructions.
May I please, your lordship.
Alright.
With the concern of the other side, I beg to mention item number 18, your lordship.
Yes.
Only 2 weeks time may be given to file additional affidavit, your lord.
Additional affidavit for what?
There are some subsequent development, your lordship, so to bring it on record, your lordship.
On the prayer made on behalf of the petitioner, matter stands adjourned by 2 weeks to enable filing of additional affidavit.
Deeply obliged, your lord.
May I please, your lordship, in item number 63 and 64, lordship, personal appearance, lordship, an affidavit has been filed. I may be permitted to bring
Yes.
that.
May I please, your lordship? Your lordship, I would beg to mention item number 25.
Yes,
The senior counsel, Mr. J. Roy, is currently recovering.
yes. How is he now? Better?
He is better, your lordship.
Okay, how much time? 2 weeks?
2 weeks, your lordship.
On a request made on behalf of Sri J. Roy, Learned Senior Counsel for the petitioner. You inform the other side?
I will put a response.
Yes,
Matter stands adjourned by 2 weeks.
much obliged.
That is your lordship. My lord, I beg for listing of a motion matter on day after tomorrow. Obliged.
I pray for listing of a matter, lordship. Notice was issued in the month of February, making it returnable
21.
after 4 weeks.
21.
Next week, any delay.
May I please, your lordship? I beg to mention item number 7, lordship. Item number 7, lordship, may be taken up in some other days, lordship. Because I need some instruction from my clients. Update this.
Okay. On the prayer of Sri D. Sharma, learned counsel for the petitioner. Matter is adjourned to be taken up after 2 weeks,
1 week, lordship.
after a week.
Highly obliged.
May I please, your lordship? Lordship, I have filed a intent with IAR, lordship, which may be come out day after tomorrow. But
I for what?
IAR for not to disturb the public fund till the disposal of the writ petition, lordship.
For some interim directions.
There is the interim direction, lordship.
You want some further interim directions?
Not, lordship. Actually, whatever no confidence motion was passed against the president, and who is before this honorable court, the petition has been filed by the president, lordship. But after getting stay order, lordship, he has misutilized.
You want to, for vacation of the stay?
Not, lordship.
So what do you want?
Vacation was there, lordship, but he is misusing the fund, lordship. So that is,
So that
There
is
is a
it, you need
direct-
some interim protection.
no, lordship, regarding the fund, no interim direction was
So
there.
what do you need in the IA?
We have a direct, we have a prayer prayed for not to disturb the public fund.
That is,
till the
isn't
disposal-
isn't it some interim protection? Respondent cannot ask for some protection.
Lordship. But he is misusing the fund, lordship, but till the disposal of the writ petition, lordship.
You will not understand. We'll have it. Yes.
My lord, I'm praying for an adjournment in item number 34, your lord.
34.
Yes, your lord.
Eh, 34 is connected with 33.
Yes, your lordship. We have informed the-
I'm at 34. I have no.
You're in 33.
My lord.
Okay, when do you want?
after 2 weeks, your lordship.
2 weeks?
Right.
On a prayer made on behalf of the petitioner. Matter stands adjourned by 2 weeks. 33, 34.
Much
Is
obliged.
there any interim order? No.
No, your lordship.
May I please, your lordship. Lordship, I'm praying for listing of this matter in the orders for lordship.
What is the matter about?
Lordship, petitioner passed B pharmacy. He applied for registration, but her name was rejected, lordship. He applied for
Rejection of registration.
lordship, under the pharmacy council, lordship.
What is the stage? Order stage?
Lordship.
Okay, next week, Monday.
Your lordship, I kindly request you to adjourn the matter for today, item 44, your lordship.
40?
44.
You're for the petitioner.
Yes, lordship.
Have you taken steps?
Your lordship, the counsel for the petitioner, Mr. D. Khan, is indisposed and unable to attend the court. today.
Okay, we'll have it adjourned. This court is informed that Sri D. Khan, learned counsel for the petitioner, is unwell. List after 2 weeks.
Much obliged, your lordship.
May I please, your lordship? I beg to mention item number 42, your lordship.
Yes.
Mr. M. Lusker is out of station, your lordship.
Who is out of station?
Mr. M. Lusker, your lordship.
Okay. Inform the other side.
Yes.
Have you informed the other side?
No, your lordship. Governments are there.
It's not government, it's a quantum matter.
Yes, your lordship.
Without information, we're not going to adjourn.
Much obliged.
Get their consent first, then we'll adjourn. Yes. Control. 10:30 বলি আছে না।
Oh. There was an order for personal appearance from the officer, my lord. Despite the a clear order, my lord, work orders were issued. My lord, as a lawyer assisting the honorable court, my only submission is, my lord, is the order so unintelligible that one cannot understand it?
No, we'll
Yes,
interact.
my.
We'll interact, don't worry. Yes, what is this, Mr. Chaudhary?
In terms of a lordship, the director of agriculture is present. Lordship, the affidavit may not come. Lordship, I have got extra.
Served on the other side?
Yes,
Yes, lordship.
come in. Given.
Mr. Chaudhary would like to see the records.
Yes.
Is your affidavit consistent with the records?
Yes, Lordship.
Have you checked the records?
A record that, yes, Lordship, on the 12th Lordship that I have produced, that record is there, Lordship. On the basis of that, Lordship, there was a noting that Lordship has stated the proceeding, but the director misinterpreted, Lordship.
Misinterpreted.
Yes, Lordship.
What about there are two orders? There are two components in this issue. There was the first order,
Yes,
which has
in
said
the
that you
760
allow him to participate, and you had allowed him to participate and rejected. Then he came up with the second case. We say we stayed the entire proceedings. Then you had distributed the work. Why was that done?
Lordship,
First part, it's a different matter. Second part is a more serious matter.
yes, Lordship, in the first part that the petitioner was.
Yes, what is your name?
My lord, I am Anantlal Gani.
You're the director. You come here. Use the microphone.
My lord, I am Anantlal Gani, Director Agriculture.
Please speak loudly. We're not able to hear you.
I tender.
No, that is not. We'll accept your reject your apology. That's a different thing.
Your Honor, I have misinterpreted the order which was given.
You have some difficulty in understanding English language.
Due to some miscommunication, Your Honor.
Do you have a problem with understanding the English language?
No, Your Honor, I understand properly.
What was so difficulty in understanding that simple language?
Your Honor, some.
The apology has to be a sincere apology. Your apology only for the sake that somebody has advised you, go and bow your head, and you think that we're going to accept it. Don't think like this.
My lord.
And we are exercising powers which is conferred by law.
Yes,
We are also not exercising powers which is not conferred by law. And you are also empowered by law to do something, but it seems that you are overreaching. You're trying to circumvent the court's order.
My lord.
And this appears to be in direct contravention. First order, okay, you have not understood. We accept it. What about the second order?
My lord, miscommunication was due to email received from World Bank.
That is the reason I wanted to extract from you. Let us see the date of the email and the order. What is the date of the email?
Email was on 6th.
When was the order passed?
On 7th, my lord.
Which order? Let us see the record. I think you are truthful with your submission. If there is something else in the record, then it will be very harsh.
No, my lord.
Let us see the email date. When did you receive the email?
Same day, on the same day.
Same day, what time?
In the evening,
5:45.
5:45.
When was the orders issued?
Order was issued on the next day morning, Your Honor.
This is your record, Mr. Gyani. Not our record. We have not written anything here.
Honor,
Mr. Chaudhary, I think might have to initiate contempt proceedings against him. You are not being truthful to the court.
On the last occasion, the record.
You're not being truthful to the court.
Your Honor.
We can send you straight from here to the where you know, but we'll not do that.
Your Honor.
We'll give you a chance why contempt proceedings should not be drawn against you. And we'll take action in accordance with law. Email is dated 6, no doubt it is 5:04 PM.
Yes,
And your
Your Honor.
orders is 6:04. Do you issue an order after 5 o'clock in the evening?
Your Honor, on the same day, because we received the email, Your Honor.
When did you receive
that
the
is my-
email? Same day we have understood.
Yes,
It
yes,
was
Your
received
Honor.
at 5 o'clock.
Yes, Your Honor, that was on the 5:30, Your Honor, on the same day I have issued the honor.
You work after 5 o'clock.
Your Honor, 5:30 is
You,
the
you,
office
you
time,
put,
Your
you
Honor.
put this on an affidavit.
Your Honor,
You put this on an affidavit. We'll examine. We'll examine. If you are not acting bona fide, you will be in difficulty. We are not against you personally, but if you are not being truthful and bona fide, and if you are not, you're trying to overreach, then it will be in difficulty. You file an affidavit. We are not dispensing his personal appearance. We'll fix the date after a week and you file an affidavit. Pursuant to the order dated 12/4/2023, Sri Anant Lal Gyani, the Director of Agriculture, is personally present. Sri B. Chaudhary, Learned Standing Council Agriculture, submits that an affidavit has also been filed today by serving copy to the other side, which however is not with the records. However, Sri Chaudhary has passed on a copy of the same. Full stop. The affidavit contains an apology by the incumbent. Full stop. The incumbent has also been heard in person. And as a part of his explanation, he submits that work orders were inadvertently issued by misinterpreting the order and also in terms of an email by the World Bank. Full stop. Juxtaposed with the records, comma, the email appears to have been received on 6/4/2024 at 5:04 PM, while the work orders were also issued on 6/4/2023. Full stop. The said action does not appear to be inconsistent. The said action does not appear to be consistent with the version of the incumbent. Full stop. The incumbent is accordingly directed to file an affidavit explaining the same, for which a week's time is granted, that the matter be listed again on, we'll have it on 26th, next Wednesday. The officer will remain personally present on the next date.
Well, may I make one submission? With regard to that biofortified maize part.
Will not mix any other,
No, my lord, if I may
no,
just-
not today, not today.
My lord, the otherwise.
The matter is too grave a matter. We will not discuss anything.
My lord, the
On the
matter is-
next date,
the matter is otherwise.
on the next date, on the next date.
Sir, by that time, my lord, the sowing season may, my lord, get over. That's
When is the repetition fixed?
It's fixed on 21st. If my lord can have it on 21st, my lord.
My lord,
21st,
my
21st.
learned friend need not be so bothered about this sowing season, my lord.
Mhm.
We all know.
My lord, he does not have any grievance.
No,
my
no,
lord.
no.
I can show that, my lord.
There's a-
Day was fixed for a specific purpose.
Matter
The
is on a
purpose
different
is-
tangent altogether.
Is a very serious one.
I
Let it
understand, my
come.
lord. It's just-
Let it come. We'll protect your interest. Don't
My
worry.
lord, will have it on 21st, my
They're
lord.
handling
Which
that
one?
also.
21st, we want his affidavit to be on record.
Okay.
Not on 21st.
26th, sir.
The records are returned back to Sri Chaudhary to be produced again on the next date fixed.
Lordship, then the whole case will come on 27th.
Yes. Otherwise, the matter was fixed on 21.
Let the matter come up 21st to his presence Lord, only for this purpose.
Other purpose.
First to repetition kada hai, to amar 26th to hai baro. Okay.
Today I have not received any instruction on the petition, but the matter will come up to 4 weeks. The matter relating to the here my petition seek custody of minor child was biological parent work in Elephant.
Yes, we had in-camera proceedings. What is the present instructions now?
We have no instruction. Let the matter will come up to 4 weeks.
See, this is a very sensitive kind of a case, and we have interacted with the child. And that is why we have taken it in camera. She seems to be very happy with your interest is with the well-being of the child. And we also appreciate your bona fide as the aunt you had come forward. You'll take care of her. But you have seen her conduct she was so very comfortable with the mother of the children home. And think over. Okay. On a prayer made on behalf of the petitioner, matter stand adjourned to be listed after 2 weeks.
May I please your lordship? Lordship, the matter has been settled. with
Settled?
them. Yes,
Okay.
lordship.
Bank, anybody who's there?
Lordship.
M. Sharma,
SBI,
SBI, anybody SBI, standing counsel? Standing counsel SBI? Who will, you can withdraw this?
Yes, lordship.
M. Bora, learned counsel for the petitioners submits that during the pendency of the split petition, the matter has been amicably settled between the parties, and accordingly, he has instructions to withdraw this split petition. Full stop para. The petition accordingly stands closed on withdrawal.
May I please your lordship?
Yes.
This is the land demarcation matter of Shankardev Sishu Vidyaniketan, Harplang law. Lordship, the school is situated on a land measuring.
Yes,
4
any instructions?
My lord, on the 5/4/2023, my lord, the land everything stuff went there, my lord. But due to the obstruction raised by the neighbor, my lord, they are not in possession of the complete land. Out of the land, my lord, they have only possessed, my lord, 3 kathas, 10 lessons, my lord. So lordship, may issue you would file the affidavit, my lord.
You file your affidavit to notice. Madam, what is your name?
Exit Hayat.
You are there on record or not? You're
Beg your
there.
pardon?
You're there on record? Yes.
Yeah.
Heard MS Jed Hayat, Senate Counsel for the petitioner. The grievance of the petitioner is with regard to the non-disposal of the application for demarcation of a land measuring 4 Katha 11 Lecha in DAG number 22/202/548 under Patta number 83 of village Hauraghat town, Mouza Hauraghat, wherein the petitioner school, namely the Shankardev Vidya Niketan, is located. Full stop. This court, wide order dated 27/3/2023, had directed Sri J. Chutia, the learned standing counsel, KAAC, to obtain instructions. But what about the connected case?
My lord, that PR has been disposed of, my lord.
Sri Chutia, the learned standing counsel, has submitted that the connected PIL has been disposed of And there are also certain developments which he would like to put on record. Puts a para issue notice returnable by 4 weeks. 3. The Standing Council KAEC accepts notice on behalf of respondent number 1, 2.
3.
1 and 2.
3 also.
Oh, okay, and 3. 1, 2, 3. Let extra copies of the repetition be served upon him. But during the court, can you do it by today or tomorrow?
By tomorrow.
By tomorrow.
That they should make the Cardiolum Autonomous Council as a party. They are make all the official respondents on the party by
By the next date, the respondent authorities may file the affidavit.
Nice. Thank you, Your Lordship. Recognize agreed for essentially.
You file affidavit. Let us issue notice then. Bora, let us issue notice. The heard MSM Bora, Learned Counsel for the petitioner, whose grievance is with regard to grant of mining area permit to the respondent number 5 without any established process of law. Issue notice returnable by 4 weeks. 3. R. Gogoi, Learned Standing Counsel, Forest Department accepts notice on behalf of respondent numbers 1, 2, 3 and 4. 3 and 4. That extra copies be served upon him by tomorrow. Let steps be taken upon the respondent number 5 by registered post to TD. Steps by tomorrow. Public.
May it please your lordship. When the petitioner before your lordship, my lord, did riot over a plot of land, which were originally Kamakha devotor land, and but later on, after the this 1959 Religious Charitable Endowment Act was passed, it was acquisition by the government and was declared Sarkari land. But we would have recorded tenants, my lord, and section according to the section 15, if any land which was acquisition under the this Public Nature Act this of 1959 Act, that has to be settled with those tenants. Section 15 says, and we have represented our case. We are occupying this land as tenants since our forefathers, and say under section regulation 23 of the Assam Land and Revenue Regulation, also these lands are to be settled with the recorded tenants only.
Registry of the Assam Land and Regulation or 71 Act.
71, sorry. Under the 71 Act. So, my lord, while these things were pending, I'm going to show from the records. These things are on records that we have applied for settlement. And actually, when it was acquisition under the Religious Act 1959.
But when was what acquired?
Pardon?
When was the acquisition done?
That information we did not have. But we were paying the land revenue under TOSI since last more than 20 years. Now, my lord.
Now, when were you dispossessed from the land?
2022, some people, my lord, started constructing a boundary wall. We represented our case before the deputy commissioner. Then it was stopped. Now they have again come.
Were you under continuous possession?
Yes, sir. We are in the continuous.
Till when? Since when? Since when were you?
The Rayoti Khotian, my lord,
It was of 19, I'm saying 19. Page 32 is the original one. And if you are riots, why do you pay a tawzi? Well, tawzi was paid because of the fact that it was declared, we did not know that when it was the acquisition by the government under 1959 Act. But kindly see section 15 of the Religious Act 1959. my lord. No, you have not challenged the declaration as government land. So that was not, when it was acquisition, my lord, there was no notice put to it. How is it possible? Acquisition proceedings without notice. Well, if it is actually without notice, that will be a very good ground for challenge. Challenge it. It was happened 25 in the year after 1959. That is what we wanted to hint upon. It's a matter, it's a stale matter. No, my lord will appreciate. Thereafter, we have applied for settlement under section 15, section 23 also. No, after the land has been declared Sarkari, you have not challenged the process. That is there. That gap is there. But that does not. Then will the Endowment Act of 59 be applicable? No, my lord, this is statutory right. That if a land is being acquisition under this 59 Act, and we know what is the statutory right. Only because there's an act, right accrues, that doesn't matter. Is there in this situation, does the act apply at all? But it applies, Lord, because we are recorded. How does it apply? Because we are recorded tenant. If you say on your own admission that the land was made Sarkari and you did not challenge the process, and you don't even know when it was made Sarkari, and you say that you are still applying the Endowment Act, the fact, which is accompanied by documents. When the particular plot of lands were declared Sarkari or acquisition under the 1959 Act, definitely the government has gone for the records if there is any tenants or not. When there are recorded tenants, it is in the record of the department. When is your challenge supposed to be made? After 20 years? No, my lord, that was not done. That was not done. But even if it is not done, my lord, my right to have the settlement does not go, my lord. To have a settlement over a land over which an act is not applicable. Under which act? What is your prayer? What is your prayer? My lord, kindly come to page 19. The prayer is at page 19. You're trying to invoke the 71 Act over a government land. No matter that government land, but my right exists under section 15 of the 1959 Act, my lord. That cannot be taken away when it is, I am a recorded tenant. You're again harping on recorded. Your recorded tenant, that status has gone long back. No, that status is gone, but by the right accrues by way of that status, that cannot. If you sleep over your rights after 20 years, no, my lord, will a read court help you? Tell us. No, my lord, what you are before a read court. What I am praying for, my lord, that the settlement must be made in accordance with the section 15, my lord. Because my continuous possession over the land since 1946, it cannot be taken away. Where is the notification of making it Sarkari? That is not there. That is why we are unable to place it before your lordship. Government can place it before your lordship, because they are the custodian of records when it was declared Sarkari. It is your petition. My petition, Milord, but these are all. Why should you burden the other side? You have to stand on your own rights, make out a case. My lord will appreciate these people are from the village. They do not even know. Don't give those kind of submission. We don't appreciate. You are in the High Court, you are saying the people are from the village. They are represented by a council. Today we are on the stage of RTI. Other cases you apply the RTI. Why not in this case? You want me to ask documents from the respondents on the first stage? Why should we? No, my lord, that is definitely depending upon your lordship wish, my lord. But what I am trying to say. It's not wish. It's the law. You have to make out a prima facie case. Documents, you know how to obtain a document. Have you applied under the RTI Act?
prima facie case is, my lord, that I have
It's a
an
gazette
existing.
notification. You are saying your village people, you don't know about it. This kind of explanation, please don't give.
But my respectful submission before Lordship is, my lord, that I have an existing right. And I have an existing right to get a settlement under two acts, my lord, 1959 and 1971 Act. And there is, while my representation, my applications are pending adjudication in at the governmental level, some people, two persons, my lord, and with the active participation of the circle officer, grab over the land. It is not a case that government wants to use the land for government purpose. No. Some private parties have come to occupy the land with the active participation of the circle officer.
These are all Tozi land. Axonia, Tozi, you're paying Tozi. Professor, your case, the documents doesn't support you. It do not support. See the documents 35, 36, 37. Madam, you take instructions.
Yes, sir.
We are having it in the motion stage. We are not very inclined to issue notice. Heard 3H or more learned conflict for the petitioners who has filed this petition with regard to certain lands over which they claim to be occupancy tenant under the Assam Temporary Settled Areas Tenancy Act 1971. Full stop. It is the admitted case that the land in question was acquired by under the Assam State Acquisition of lands belonging to religious or charitable institutions of Public Nature Act 1959. Full stop. Para. MS and Bodlo Land Standing Council Revenue is directed to obtain instructions. Full stop. The matter may be listed for motion again on today is 19th. We'll have it on 8th of May. Let an extra copy be furnished to Ms. Bodlo during the course of the day.
I would like.
May I please, Your Lordship? The matter pertains to
Installation of mobile towers is what
before Your Lordship to give a direction to the respondent number 4 to dispose of my representation, Lordship. And similar order, it's passed an order on similar matter, Lordship. May I have a look kindly?
What is your legal right?
Lordship, as per guideline, Lordship, I am having existing tower. I have a tower. I am operating a tower on my own land, Lordship. For the guideline issued by the concerned department, Telecom department, Lordship. The new tower cannot be installed within 1 kilometer radius of the existing tower, Lordship. Here, Lordship, what happens, Lordship, the tower in question has been constructed within 200
Let us see the
radius, Lordship.
guidelines. Let us see the guidelines.
Hello.
Which one?
Lordship, I find a government of India, Ministry of Environment and Forest, Lordship.
No, guideline number, which is the number?
Of is Page number 3, Lordship, paragraph 4, Lordship.
No, that your distance factor, which is
Distance factor, Lordship, I'm talking about distance factor, Lordship. Government of India, Ministry of Environment and Forest, Lordship, the guideline issue. Advisory on the use of mobile tower in a way to minimize the impact on wild and green birds in this Lordship. To page number 3, paragraph 4, paragraph 1, Lordship.
Now, where have you stated it is within 200 meters?
Lordship, in my report is on page 5, Lordship. Now find that paragraph 3. Only direction, Lordship, to the respondent authority to dispose of my representation, Lordship, giving a hearing, Lordship.
No, these are factual matters. Without being satisfied, will not direct. It's not a post office. You come, they give a direction for consideration. No. Your Islam,
Lordship.
first Islam learned concept for the petitioner who is aggrieved by the installation of a mobile tower by the respondent number 7 near the existing tower of the petitioner. Full stop. The learned council submits that the new tower is being constructed at a location which is less than 200 meters from the tower of the petitioner, and as per the guidelines of the Telecom department, comma, the minimum distance should be 1 kilometer. Full stop. Islam has drawn the attention of this court, drawn the attention of this court to the averments made in paragraph 4 of the writ petition in this regard. What's the para? Issue notice, returnable on. Well, these are, you get the instruction, try to dispose this of. If actually is correct and the guidelines have some statutory force, we may direct it.
In fact, I'm appearing for pollution board. The board is nowhere related in this case, in fact. Previously, for the DG set, they ought to have received subsequently.
Okay, returnable on. Will have been on 15th of May. Who will accept notice?
I can accept notice for 1, 4, and 5, my lord.
M. Burman, State Council 1, 4, and 5. Respondent number 2.
In Commissioner
Ministry of Information.
In fact, if it is the ministry, it has to be the Union of India.
Union of India.
Ministry of Information, does the state government have a Ministry of Information?
Now, my knowledge doesn't.
Lordship, in their guideline issued by the state government, Lordship, it has been mentioned, Lordship.
No, is there a
There is no
Ministry of
ministry.
Information in the state government?
In the guideline itself, it is mentioned, Lordship.
It's your petition, we are not going by the guidelines. Is there a ministry? If you say yes, we'll issue notice. If you say no,
In my information, no, Lordship.
then why do you make?
In the
1, 3N, madam, or not 1, 3, 1, 4N,
1, 4, and 5, my lord.
1, 4, and 5.
I appear for 3.
As Borua for respondent number 3.
And I'm for 6.
As Dr. Standing Council PNRD for 6. Let steps be taken upon the respondent number 7 by registered. Let extra copies be served upon the learned council for the respondents. Steps be taken for service of notice upon the respondent number 7 by registered post to DD. Steps by tomorrow. At this stage, since there appears to be some anomalies in describing the response number 2, comma, at this stage, no direction for service upon the said response number 2 is given.
May I request my friend to give a set of guideline to copy of this?
This will get in the net.
As it is not annexed with.
You should have annexed this. This is
Yes,
part,
my lord.
I think this is the essential part.
If I do William, that entire.
One submission, Lordship. Pendency of this petition, Lordship, that shall not be a bar
Yes.
to dispose of that.
Pendency of this petition shall not be a bar for consideration of the representation said to have been filed by the petitioner.
Obliged.
The petitioners, my lord, are in possession of land since 1991, my lord, and my lord, there is also a proposal for allotment of land in favor of the petitioner.
Why from 2021? The matter is at the motion stage. You file affidavit.
I file affidavit, my lord.
We'll take for admission hearing.
My lord,
Doesn't look
respondent number
good.
3 has already filed affidavit.
Huh?
Respondent number 3, Deputy Commissioner has already filed affidavit. May take up for admission, my lord.
We'll fix for admission.
Yes.
What is the matter about?
Well, here the petitioner, my lord, number 1, actually a land was proposed to be allotted in his favor, my lord. There is also proposal, my lord. But later, my lord, they want to evict the petitioner from that land in which he was supposed to get allotment.
You are possessing that land.
Yes, sir.
He had applied for allotment.
Yes, and it
There was a
also approved.
proposal for allotting to you.
Yes, ma'am.
Now you are supposed to be evicted.
But some persons came on in the month of.
Sarkari land.
Yes, ma'am.
What was the process? What was the stage of the process?
My lord, the state advisory board, my lord, they approved the proposal, and thereafter. my
What
lord,
is your stand, madam?
Yes.
My lord, as per affidavit that relates to Tawzi land number, para 5.
No, that is Tawzi, but he says that he had applied for conversion and it was taken up by the state level committee. What has happened thereafter? Is he landless?
Report was called for, but after that, nothing happened. Yes, your lordship, I will.
Sri I. Chaudhary, Learned Counsel, for the petitioners who are residing over a plot of land covered by DAG number 688 of village, North Lakhimpur town, part 4, Muja Lakhimpur, and claim to be in continuous possession for a long period of time. Full stop. The petitioners claim that they had applied for allotment, which had also progressed. Full stop. However, on 3/10/2021, comma, there was a move. There was a move to evict the petitioners from the same plot of land. Full stop. Para. Though this case was instituted in the year 2021, in October 2021, comma, notice of motion is yet to be issued. Full stop. However, the response by the state authorities is on record by way of an affidavit filed on 17/11/2021, which was also replied to by the petitioner. Post para. Issue notice returnable on on 17th of May. Since the respondents are already represented by MS.M. Burman, the State Council, as well as MS.N. Bordloy, the learned standing on the revenue, no press, there is no requirement to issue formal notice. There is no requirement to take fresh steps. List, as directed above, list for admission on 17 May.
Obliged.
May I please? My lord, kindly adjourn the matter for the day, my lord. We are going to file additional affidavit today, my lord.
On the prayer made on behalf of the petitioner, matter stand adjourned to be listed after 2 weeks to enable the petitioner to file additional affidavit as prayed for. Yes,
Not on the previous order dated 3/4/23, and the opposite party had been directed to the matter related to assessment of compensation, my lord.
I don't know, the assessment of compensation. The direction was given, what is the status of the competent authority? The competent authority already fixed the matter for hearing in the end of this month. So let the matter be disposed of, let the matter be disposed at this stage, and then the matter be sent to remand to competent authority.
now when is the hearing fixed? End of this month.
End of this month.
Have the hearing done, we'll have this pending. After that, you inform us what is the outcome.
But then there will be different court option. No, they want that, they want compensation. And
No, hearing is for what?
hearing for not a counter, whether they are entitled to get the compensation or not. Whether the land falls under that otherwise.
No, those are, those two,
Get a matter evidence.
no, those two issues are intrinsically connected.
Yes,
You are saying that they are not even entitled for compensation.
yes, we are saying that they are not entitled for compensation.
That is what you are having a hearing.
Yes.
And they are saying that they are entitled to, but that which is the subject matter of this petition.
Yes.
You decide on that, your matter, we'll have it immediately thereafter.
My lord, I have approached to the competent authority. There specifically says that I'm not entitled for compensation. But my saying is that, my lord, I am highly entitled for compensation. There's an issue, my lord, that I am sitting on 254,
Mhm.
but the respondent authority says that I am sitting on 255. But I have record.
But these matters will involve factual determination. Can we do that?
My lord.
Can a writ court determine factual aspects?
No, my lord, this is why the matter is purely civil nature, but I have barred from this act to go to civil court, my lords.
No, no, why? You can go to the competent court of principal competent court of the civil jurisdiction. There's the act. Yes, what is the provision?
Well, the provision is that whether any person agrees.
Yes.
Yes, that he can competent authority will decide, and if there's not.
There's a competent authority.
District judge.
Competent authority is the district judge.
Yes.
It is almost it's almost at par with the civil proceeding.
So they
Same
are not
evidence.
that's what I'm telling you, they are not satisfied what they are wanting.
Same proceeding.
Yes,
Not only this act, even the Telegraph Act, Electricity Act, everywhere, the same provision. The district judge is given the powers.
Yes, my lord. So that's what I'm saying, this matter to dispose of, my lord, because unnecessarily they create a hurdle. Huh?
My lord, under section 9 and of Petroleum and Mineral Pipeline Acquisition of Right of Users in Land Act 1962, my lord. It is Act section 9 clause 3. where the owner or occupier of the land with respect to which a declaration has been made under section subsection 1, section 6, construct any building or anything which has been constructed there, the competent authority have given some power to send the matter to the district judge. I have not been given the power, my lord.
No, that's not correct, not correct, not
I am
correct.
requesting the competent authority.
Let
my
us-
lord,
let
to
us
send
see
the
the act.
letter to the district judge.
Let us
to
see
say
the
that
act.
the district
Yes,
judge-
my lord.
Let's see the act.
This, this is not the way. Competent authority cannot refer the matter directly to district judge. Competent authority will decide. Yes, maybe misreading the act. Interpreting the act. উল্টা পড়ে যাবে তুমি। একটু শোনা, একটু শোনা। তারপর একটু বুঝতে গেলে পুরো একটু একটু পুরো লিখিয়ে দেবে, কি মাথায় ঠিক আছে। একটু
Compensation to ঠিক আছে, কিন্তু matter to compensation-
First, we have to come from the very beginning. The owner or occupier of the land with respect to which a declaration is made under subsection 1 of section 6 shall be entitled to use the land. So subsection 1, section 6. That has to fall within their jurisdiction, my lord.
Section 10, I think, takes care of your,
Yes, section 10 will take care. That's what I'm telling you. Section 10, subsection, subsection, section 10, subsection, the competent district, that
subsection 2, then
subsection 2,
6.
subsection 2, my lord.
It is only after the decision is taken by the district judge, perhaps you can come to a writ court or a revisionary court, because that decision will be a final one. There is no other appellate
In
authority.
section 10, compensation, regarding compensation, my lord, after determining the competent authority about compensation, I could go, if I'm not satisfied with the competent authority, then I have to proceed to the district judge. But before that, I have not given this.
Has the compensation been,
What compensation they are determined is the basic, my lord, because already my house has been demolished. Already I am suffered, my lord. But no compensation when approached to the competent authority, they have said that I am not
no,
eligible.
if they
for
are saying that this
compensation.
land is not even part of the
Part of the ROI.
proceedings, ROI,
Hmm.
then it's a matter which is
You are not in the, he is not
which is
entitled to
within
get
the
any compensation.
factual, the factual matter. We cannot. Then where is the bar to apply, to go to a civil court? If we accept your submission,
My
that
lord.
10, application of 10 will come only after determination of the compensation, if you are agreed by the adequacy, isn't it?
Yes, ma'am.
If you say, if you think that the compensation assess is less, then you can go for an enhancement. And here in this case, there is no compensation even determined, because they are saying that the ROW is not affecting you. That is their case, which you said it is not their case, it's affecting you. And for this matter, why can't you go to the civil court? Where is the bar?
My lord, section 14, bar of the jurisdiction of civil court.
For what?
For what?
Things,
That
Will this bar be applicable?
Bar of jurisdiction, such as other explicitly provided in no civil court shall have duty in respect any with the competent authority empowered. Which the competent under that to determine no injunction shall be granted. That is a different issue, my lord. That injunction cannot be granted if they want to demolish.
This is a bar which acts against you to stop any acquisition proceeding or proceedings undertaken by them for the ROW.
Yes.
Now we are saying that you are entitled to compensation because you are affected. They are saying that you are not even affected, you are not touched. To determine this factual aspect, you can go to the civil court. We cannot perhaps, because we do not have that expertise. You cannot deal with evidence here.
Matter of evidence, my
You will
lord.
say something, he will say something. How do you determine? We'll have this in the admission stage. You come prepared, we'll dispose this of. We can have it on Tuesday next.
My lord, one thing that when I am taking permission at the time of purchasing the land, the same office says that this is 254 after verification of everything. And this is on record, my lord, all the documents I have attached to it. But after some years, when the acquisition come, then my land quickly becoming 255. So there's a
Those are all
conflict.
factual
What
aspects.
governmental authority says.
Well, one thing I want to point out, my
Okay,
lord,
Tuesday next, we'll have it for admission.
if you also go through the their prayer for portion 4, my lord. An appropriate order of direction should not be issued to a despondent. If you also go through the paragraph 4. Whether
My
it
lord,
is mentioned, my lordship will decide.
My lord, my lord, if give
An
direction. to the
appropriate order or
state authority, I have no access to the Google map, my lord. If direction has been given to the authorities, then I could more visibly explain that what is happening in there. Because I don't have any access to
So,
Google map, my
so
lord.
the appropriate order and direction should not be issued to a respondent. That is the Joint Director Survey Assam to consider and dispose of the application. So there is a multiplicity.
What is your
of-
name?
Deep here, my lord.
Heard Sri Deep Bhuya, learned counsel for the petitioner. Also heard Sri S. Mitra, learned
Standing
standing counsel
counsel.
Gail. Full stop. Sri Mitra is equipped with the instructions and submits that the matter can be disposed of at the motion stage itself. Full stop. List again on today's, and we'll have it on
25th.
25th. 25th.
I can give you my, I can give you a next data before that.
Produce it on the next day.
Yes, man.
Yes, next. Yes, what is this?
Yes, my lord, just a backdrop, my lord, images. My lord, what has happened, my lord, the petitioners before your lordship are vendors in the railway platforms, my lord, static units. My lord, there were a series of litigation, I should say, my lord.
Who is for the respondents? Railways, I think. The CGC, some CGC would be there.
Huh?
Anyone? Would be there?
Although this matter has not been allotted to me for today, also I can take the notice and I can inform the group also.
We don't have any issue. We can have it day after tomorrow.
My
Is
lord,
there
on
any
the
other-
last occasion, Standard Council Architect Chaudhary appeared, my lord. Last occasion.
Can you inform him?
Yes, I can inform.
We can have it at 2 o'clock or day after tomorrow.
At 2 o'clock, also.
2 o'clock. Let him, because his name is not been shown.
Yes,
He might have some instructions.
yes,
2 o'clock.
Yes.
Both the matters.
yes, both the matters.
None appears for the petitioner on call, whereas Sri A.K. Datta,
1 and 2, my
CGC,
lord. 1 and 2, my lord.
learned CGC is present along with, footstep. So is MS M. Borman, learned State Council, as well as MS M. N. Bodler, learned Standing Council Revenue Department, footstep, para. As per office note dated 27/3/2023. No fresh steps by registered post with AD, as well as usual process has been taken by the petitioners so far as the response number 6 is concerned. Full stop. Para. that in the interest of justice, that the matter be adjourned by a week to enable the petitioners to take steps upon the said response number 6. Full stop. It is however made clear that in case of further default, this court may be constrained to pass appropriate orders.
The last occasion, my lord, there was some direction to take instruction, whether my lord, the impugned order is reviewed or not. But because of my lord vacation, my lord, if it is there, I'm not unable to collect it, my lord. Lordship, we kindly-
We'll have it some other day.
My lord.
Well, today is 19th. We'll have it on 3rd of May. Is it okay? Or 28th of April, whatever you say. 3rd May. On the prayer of Sri. Done sometime. On the prayer of Sri P.K. Sharma, the learned additional foreign advocate of some matters change adjourned to 3rd of May to enable him to seek instructions. The interim order passed earlier to continue till the next day of listing. In person as okay. The gentleman here are appearing in person at arbitration matter.
Item 32, Lordship.
Arbitration matter.
Lordship, the item 32.
And the body, 32. So, and other side present or not?
Not present, Lordship. Mr. Gupta, he is not here.
32 H. Gupta.
They asked for time for taking some information from the department.
Can you get hold of him?
Well, I'll try, Lord.
We'll take your matter and we'll relieve you. Ask him to come.
Now, in this matter, we won't be appearing any further. We like to withdraw ourselves from this.
Have you informed your clients?
We have been trying to communicate with the client, but he is no response from his side.
Send a registered AG.
We have done that. We have also communicated over WhatsApp also and tried to call.
No,
also.
have you done registered AG?
Registered ID because the address which is there with us, he has shifted from that address also.
You inform the registry at least. You give a written thing, application. Dr. A to D. Learned counsel for the petitioner submits. That in spite of best efforts, there is no communication with the petitioner, and therefore he may not be in a position to appear any further. Full stop. The state back may be informed to the registry by an application which may be put on record that the matter be listed after a week. Then we'll delete your name. Is there any interim order?
No, Lordship.
Yes.
Sorry, Lordship. I was in another, in fact, Lordship,
doesn't matter.
65, 66, Lordship, it escaped my notice, Lordship. He agrees that if it can be taken up on Tuesday.
Immediately after 8, my lord.
When on the prayer of the Archdeacon Chaudhary.
26, 27, any day, my lord.
Learned so. List on
26th, my lord.
list on 26th. Okay.
I'm extending.
Raise cause this to reflect the name of Sri Archdeacon Chaudhary. So. Okay.
Deeply obliged, my lord.
Your Lordship, my senior, Miss M. Hazarika is on her way.
Who's on the other side?
Lordship, in fact, I appeared for the railway, Lordship. Follow, Lordship, in spite of my best efforts, Lordship, I have not been able to get any instructions from that.
You have not filed your affidavit also.
No, Lordship. Because, Lordship, so many letters, Lordship, nothing has come.
But we had adjourned the matter to take instructions whether mediation is possible.
Lordship,
Whether mediation is possible.
willing to go for mediation. We've been telling them time and again.
Even now, Lordship, I have communicated, Lordship.
No, you,
Because
ask the officer if they not respond and we know how to make them respond.
Subject to, if Lordship provides in the order, Lordship, if nothing comes, some officer has to be personally present. Because I've been writing letters after letters.
And Lordship, since 2014, my goods are lying there.
Is when this matter was taken up on 19/7/2022. The matter was adjourned to enable the parties to come to a consensus for a settlement through mediation. Para MSM Hazarika, senior counsel for the petitioner submits that the petitioner is ready and willing for such a course of action. However, Priyanka D. Chaudhary, appearing for the railways, submits that there is no response in spite of his communication. Para. In view of the above, the matter stands adjourned, giving another opportunity to the respondents to act in terms of the order dated 19/7/2022. That the matter be listed again on 3rd of May 2023. Failing which, if no response is received, the court may explore passing of necessary orders to secure the presence of the concerned officer of the respondent.
Lordship.
Let a copy of this order be furnished to Priyanka D. Chaudhary, done it so and so, to enable him to do the needful.
Lordship.
Would the cases
Both the cases.
Yes, come.
Yes, Lord.
Say Gupta, anything? He is in person, so we wanted to upgrade. Yes, anything?
Lord, that is basically for appointment of an
Arbitrator,
arbitrator.
have you had the instructions?
Lord, although I have no instruction as on date, Lord, although there is a communication.
It's only for appointment. This is nothing, it's not an education. Almost an administrative function.
My lord.
You get the instruction, we don't want matters of this kind
Lord, I
to.
will get instruction, my lord.
Next day, we're going to dispose
My lord.
of our instructions. Sri Ghanashyam Das Dhiman,
Lordship.
partner of the petitioner, has appeared in person. Sri H. Gupta, learned CGC, appearing for the respondents, prays for some more time to get instructions. Para, considering the subject matter of this case, which is only for appointment of an arbitrator, time of 2 weeks is granted.
Lordship, fixed date kindly, ma'am.
2 weeks is granted to Sri Gupta to obtain instructions. Full stop. It is expected that instructions would be obtained by the next date as By the next date, full stop. List on 10th of May. Into item 32%. Any improvement, development?
Some development is there. I'm told that some preliminary report has been filed meanwhile, and the final report is awaited. Lordship may have, in your.
Preliminary report shows some promise.
Yes, that is what my instruction is.
Okay, we'll grab some time. A note dated 5/4/2023 by the Secretary, Mediation Center of the Guwahati High Court. States that a preliminary report has been submitted by the mediator who was appointed in this case. Which, full stop, it appears that a spot verification was also made by the learned mediator, who has prayed for some more time for the final report, full stop para. In the interest of justice, matter stands adjourned by a month, by which time the final report may be submitted by the mediator, by the learned mediator. List on, we fix a date, Mr. Mahanta?
Yes, maybe on the third week of May, 17, 18, or like this, or 22nd.
We'll have it on 24th of May. Wednesday, 24th May. Yes, next.
Lordship, here, in fact, there are two things, Lordship. In the constitution, the JSM is not being shown. And second thing, Lordship, I have borrowed a file from the Revenue Department. I've seen the representation. That representation is to the PW Department. I think, Lordship, it has to be before the collector, because under the new act, it is the competent authority is the collector.
None appears for the petitioner on call, whereas three TKS Barwala State Council, along with MSN Board Law and Standing Council Revenue are present. Para, be that as it may, be that it may, and in the interest of justice, that the matter be listed after a week. Full stop. Registry to reflect the name of TKS Barwala and State Council in the cause list. PWD, who's appearing?
Also, instead of CKS, but also GSM may be recorded.
GSM, registry to reflect GSM in the cause list. Second, what it is?
Well, these are regarding the non-payment of bills. That matter on the last occasion,
Yes, handloom textile.
handloom and textile, and on the last occasion, this AGMC advocate for AG appeared and submitted that their instruction, they have received instruction and they will file the affidavit.
Where is Mr. Dhar? And I think who appeared?
One A Talukdar means MS A Talukdar. He appeared for AGMC.
Name shown or not?
No, she was there, was right. She has not yet filed. He told me that she will file within today itself.
She knows about the matter.
She knows about the matter.
We'll have it after some time. Try to locate them.
Yeah, please, your lordship.
You're for whom?
Your lordship, I am for the respondent number 1 and 2, your lordship, the Gale Authority, your lordship.
You're for Gail, who's for the petitioner?
Petitioner, your lordship, as brought up for the learned council.
Your IA is there for what?
Your lordship, in the course of this proceeding, your lordship,
Hmm.
the IAs, your lordship, they have filed the IA, your lordship, the petitioner, for the withdrawal of the amount, your lordship, that has been also been taken to the Honorable Supreme Court, your lordship, where a direction was given that only 80 lakhs would be paid, your lordship, to the petitioner, and the petitioner would have to hand over the possession, your lordship.
IA is for a different purpose. You want to withdraw certain statements.
That was being taken care of by the Honorable single judge, your lordship. It was
Where?
filed in the month of September, your lordship. Withdrawal of statements, that was in the first part of the proceedings, your lordship.
But no order is passed in the IA. The order has been passed in the main case.
Yes, your lordship.
Which order?
Your lordship, perhaps some has been reflected in the order, your lordship. Your lordship, order 411/2022, your lordship, perhaps is the order. There, the IA has also been linked with your lordship.
What is to be done today?
Your lordship, as the petitioners have already informed me that they would seek time, your lordship, because of some difficulties, your lordship.
Okay, we'll adjourn the matter.
Yes, your lordship.
None appears for the petitioner on call. However, Sri D.S. Decca, Senate Council appearing for the game, has fairly submitted that he was informed that an adjournment would be
Yes, your lordship.
sought for on behalf of the petitioner.
Yes, your lordship.
Mr. Patta, in the interest of justice, the matter stands adjourned by 2 weeks.
Your lordship, date may be fixed, your lordship, 11 May.
Registry to release this matter on
11 May.
we'll have it on 8th of May.
8th of May.
8th of May.
Much obliged, your lordship.
Madam, you're appearing for whom?
Yes, in this matter, your lordship, she's also assisting.
Gail.
Yes, your lordship, she's assisting me.
Okay.
Much obliged, your lordship.
May I please, your lordship? I
Yes.
also file affidavit today, lordship, and I
Yes.
just received the copy, signed copy, lordship. During the day, course of the day, I will file,
Okay.
lordship,
8 Alugdar.
lordship.
MS
For
8
respondent
Alugdar.
number 4.
Learned Counsel for Respondent number 4 submits that the affidavit in opposition is ready and will be filed during the course of the day. Let the matter be listed. Let the matter be listed
My lord, 25th.
on 25th will be okay. Will not file any affidavit, reply affidavit.
Sir, I think it will not be.
Okay, we'll have it on 25th. If there is a requirement, we'll consider it. Let the matter be listed on 25th along with the affidavit that may be filed in the meantime.
Deeply obliged.
Separate orders, huh? You take it up. That order report number will be received.
May I please, lordship? My lord, this case released to the my lord, asks for our vehicle, my lord, which has been on run with the agreement with the driver, my lord. He has to give me 50,000 per month, my lord. Accordingly, my lord, the driver was caught with a sub-foreign made cigarette. Accordingly, my lord, the vehicle was seized. And I have approached to the authority, my lord. Then authority passed an impugn order at page 119, my lord.
Pleadings are otherwise complete.
My lord.
We file our affidavit.
You file your reply also, I think. If you say we can have it for disposal,
Yes, my lord. It can be
When?
disposed.
when?
Yes, but conveyance.
Today?
Lordship,
Today, not today.
today lordship may any other day.
My lord is my commercial vehicle, my lord. It's lying on the open
He's
shelf.
to overcome from the hangover of Bihu.
Lordship. On Friday, my lord.
When?
Friday is Friday, my lord.
Friday is not possible. Have it, you can have it tomorrow or Tuesday next.
Lordship.
Pleadings are complete. And the parties are in agreement that the matter can be taken up for final disposal at the admission stage. Full stop. Sarah, as agreed to by the parties, list on (27th).
Lordship.
25th, 24th is a holiday, 25th, no, 27th,
Lordship.
Thursday. Welcome. Status quo. Status quo was directed.
Yes, your lord.
On a prayer made on behalf of the Forest Department. Matters can adjourn by 2 weeks to enable a seeking of instructions, to enable furnishing of instructions. Sarah, interim order passed earlier to continue till the next day of listing.
My lord,
Should we fix a date?
revenue department also wants to take instruction because I have submitted some chithas. They want to.
Okay, no, her,
was-
interim order I would prefer. In the revenue department may also obtain the instruction,
We have communicated with the department.
may also obtain the revenue department may also furnish the instructions in the meantime. After interim order to him.
Yes, your
Lordship, on this matter, senior officer PN Kusam, he is on legs in court number 1, Lordship. Matter may be taken up after some time.
After some time.
Lordship can it be taken at 2 o'clock, my lord? By this time I'll finish up my work.
2 o'clock. 2 o'clock. So now what is this?
My lord, this application is filed under section 11(5) of the.
Yes, any instructions?
No objection if arbitrator is appointed, my lord. He has got no objection.
You suggest the name?
My lord, I have just consulted with him. Mr. Justice, retired Justice BP Kotoki appointment is confirmed by him.
Heard. 3 DM Nath, Learned Counsel for the petitioner. Also heard 3
A.N. Sharma, my lord.
A.N. Sharma, Learned Counsel, appearing for the respondent numbers.
All the respondent, my lord.
For the respondents. This is an application praying for appointment of an arbitrator for this an application praying for appointment this is an application under section 11 within bracket 5 of the Arbitration and Conciliation Act, 1996 for appointment of an arbitrator. Full stop. Notice was issued on 9/1/2023, whereafter the respondents have appeared who, as indicated above, are represented by Shri Sharma. Full stop. Sarah? Both the learned counsel have arrived at a consensus that an arbitrator be appointed to adjudicate the dispute. Full stop. Both the council have have suggested the name of Honorable Justice retired BP Kotoki. Full stop. Sarah. After hearing the parties and considering the aforesaid submission, the present petition is disposed of by appointing Honorable Justice within bracket retired Mr. B.P. Kotoki to act as an arbitrator to adjudicate the dispute in accordance with law. Full stop para. The parties may approach the learned arbitrator within a period of 2 weeks
Hello.
from today.
Hello.
Whereafter the learned arbitrator would take charge of the matter.
My lord, if possible, a date may be fixed for appearance before the.
We do not know his availability.
My lord.
It is not a court.
My lord. I understand.
You would go on an agreed date.
Yes.
You
We'll
try to, yes, agreed date, go on an agreed date. And once you have his, you can have him, then he'll take charge.
My lord.
2 weeks, Koloniki, within 2 weeks.
Obliged.
This petition still disposed of.
Obliged.
Yes, what is this?
Yeah, please. Hello.
Any instructions, Mr. Gogol?
Lordship, we have placed one instruction whereby we stated that the NOC is not valid, your lordship. No need you. So
Lordship, in this case also, the honorable court pass an order, lordship, last case on. Right to file an affidavit.
we'll put this on record, your lordship.
Actually, whatever, my lord, in this fact of the case, my lord, lordship, petitioner applied for installation a lordship, a unit of the stone crusher, my lord. Accordingly, verification was done, my lord, and there is several NOC was obtained from the defined authorities, my lord.
You file an affidavit.
Well,
My lord, in the meantime, my lordship, we have filed an IA, my lord, to make a party, my lord, to
Whom?
concern DP president, my lord.
Whom GP president?
Yes, my lord.
Why?
He is not lordship issuing this certificate, my lord. We have stated in the IA, my lord,
We have to issue notice before implementing.
implementation, my lord,
We have to issue notice to him
my lord, my lord.
in the IAU, right? Archer JUNM Laskar, counsel for the applicant petitioner, who by means of this application has prayed for implement of the president Tiklapar Gao Panchayat as respondent number 6 in the connected WPC 1476/2023. The learned counsel submits that the said respondent, the said party which is proposed to be implemented, is a necessary party whose presence would be required for a fair adjudication. Full stop para. Issue notice returnable by 4 weeks. Let steps be taken for service of notice upon the party sought to be implemented as respondent number 6 by registered posted AD. Steps by tomorrow. And in the main writ petition, you write, the R. Gogoi, Learned Standing Council, Forest Department raises an objection regarding the validity of the NOC. Full stop. The said objection may be put on record by way of an affidavit. List after 4 weeks.
Obliged.
Yes, instructions. Madam?
Yes, my lord. I have received lordship terrorist commission. Lordship may kindly allow me some time to file my counter affidavit.
Other respondents? While MSVL Singh, and Standing Council NHIDCL submits that instructions have been received, comma, the instructions from the other respondent are yet to be received as informed by MSS Sharma, the learned state council, full stop para. List after 4 weeks to enable obtaining of instructions, filing of affidavit in opposition.
Any date maybe?
Yes, next.
Lordship. My lord, any date means
Okay, what is the matter about?
matter lordship with by the there is a process for acquisition of land was initiated and our land 100 feet was acquired by the proposed map lot. We are agreeing 60 feet but objecting only 40 feet.
List on 22nd of May.
Or like
Lordship, my name is Espiro is in legs, your lordship. Kindly pass over time being.
My one,
The other day, your lordship heard the matters and I have gone through the file, my lord, because initially, possibly it was with me for some time thereafter file was taken away. And what has happened in this case, 2-3 things are here. One is, my lord, your lordship has seen a notice under section 21 was issued for violation of section 20 of the Assam Fixation of Stealing on Landholdings Act. That is a completely different proceeding. A show cause notice was given, they have been reply, and the final order was passed. That they have challenged. But in the petition, my lord, they have also brought into the record that under the Entry Tax Act, some exemption was given. Then for industrialization, some policy is there. This is second aspect. Third is the change of the status of the person who purchased the land, which fell under the land ceiling surplus, which was a ceiling surplus land, and petitioner is different. This issue also they have brought here. So 2-3 issues they have brought here, and there is no affidavit on the part of the respondent government. My submission before lordship in such a matter when it's a land of about 100 bighas. Possibly an affidavit should be there from the state government because 2-3 departments are involved here. There is no affidavit. And I argue on my own only on the question of law, but there are some factual matters where unless there is an affidavit.
When we come to the prayer, we may not be too much bothered with the other aspects.
Well, that's what I'm saying. If your lordship confines
Yes.
to only the validity
Those
of the final
incentives
order passed,
yes,
then
yes.
my lord, I can argue, don't know difficult.
We are not going to those aspects
Yes,
of
ma'am.
incentives and other things.
Yes.
We will concentrate on the prayer made. They have come for against the order of 10, 20 to 25 to 15.
My lord, yes.
We'll
That is the
concentrate-
order under challenge, and that I'll have to defend in terms of the provisions of the
Yes, that is all.
1956 Act.
That is all. That is all.
And that can be done.
So 15 matter, we are on the journey.
My lord.
When? 2 o'clock.
2 PM is final.
2 o'clock. 2 o'clock.
My lord.
We'll have it, this matter as first at 2 o'clock.
My lord.
Obliged.
Please, my lord. No, this writ has been filed challenging a demolition notice issued by the respondent number 1 and 2. The petitioner is the owner of a small scale industry, my lord. They wanted to set up a small scale industry in the area which, according to the respondent number 1, falls in the master plan and the zoning regulation 2025, my lord. That is their case now. If my lord takes up Annexure 1 to the writ petition, my lord, page number 15. My lord, the Mozarts have been specified there and the corresponding villages, my lord. If my lord turns to page number 17, this is a certificate issued by the Office of the Circle Officer, Azara Revenue Circle, Azara, my lord. if I may read, my lord, certify that the land
What
measuring
is the
5 feet.
status? What is the status?
My lord, the factory is functioning as of now. It is a ready mix concrete plant. All the necessary permissions have been enclosed, my lord. They have been acquired from the Azara Gaon Panchayat, my lord. The NOC and the trade license, my lord, under section 25 of the Assam Panchayati Raj Act, my lord. The pollution control board certificate, my lord, annexure 4 series at page 22, my lord. The government of Assam and the chief inspector of factories has also issued a registration and license to work a factory, my lord. It is at page number 24, annexure 5, my lord. All the permissions have been acquired, my.
No, we are not
And my lord,
so
the
much
area.
concerned with the other authorities.
My lord,
We are concerned with the orders filed by the GMDA.
my lord.
Who's you're representing GMDA? Yes, yes.
But they have not taken any concern NOC from the GMDA, my lord. This
My lord.
fact, lordship, we have filed affidavit, my lord.
My lord, the area does not fall within the notice, my lord, which was issued by them. It is at page number 25, my lord.
Hmm.
They have stated that whereas you have undertaken or carried out development of building and land within the GMDA area covered by the master plan and zoning regulation.
Hmm.
My lord takes up the master plan and zoning regulation. The Moza Ramsarani is not mentioned, my lord.
Where is it?
My lord, page number 15, my lord.
15.
Yes. Kila Hinduri Bhupa. My lord, and the rest are mentioned, my lord. Beltola, Ulubari, Guwahati, Jalukbari, Ramsaramini, Moza has not been mentioned, my lord.
What is your response to this, madam? Tutia? Is it outside your territorial jurisdiction?
No, my lord, kindly come to, we have filed affidavit, my lord. Page number 4, my lord. Paragraph 3, my lord, in the paragraph 3, we have clearly stated, my lord. Page 4, paragraph 3, my lord.
One moment. Yes, Pamohi.
My lord.
Oh, just a minute, just a minute.
Yes, ma'am.
Pamohi is there. Pamohi is there.
My lord, the village is there, but the Moza is not there, my lord.
But if the village is the same,
My lord, Pamohi village under
Jalukbari,
Jalukbari Moza, my lord, not
Are-
Ramsarani Moza.
are there two more Pamohi?
My lord,
Have you
Pamohi-
have you made an averment that this is not the Pamohi where your factory is situated?
My lord, averment to that effect has not been made, my lord.
No, it is for the authorities to say. You may find a fault with the schedule. Schedule may not be the appropriate one, but Pamohi is definitely there. How can you say that Pamohi is not under GMDA?
My lord, because it is under the Gaon Panchayat, my lord, Azara Gaon Panchayat, my lord. The Moza, my lord, if the certificate, my lord, peruses, it is stated it has been given by the
Pamohi is under the Gaon Panchayat.
Yes, my lord. The Moza Ramsarani, my lord.
We are not on the Musa, we are on the village where the factory is situated. So yes, what is your stand?
My lord, para 6, my lord, page 5,
Page
5, my lord,
of the affidavit.
of the affidavit, my lord. Second para, my lord, the
Filed by
state-
whom? Devraj Kolita. Town planner. Filed by the town
Devraj
planner.
Kalita, my lord.
Yes. Paragraph.
Para 6, my lord, second paragraph, my lord. The statement made in this paragraph to the effect that Ramsarin Morza does not fall within the notified area of GMDA as described in Schedule 1 of Master Plan 2025 is wholly correct, and the deponent state that Pamohi village in which petition unfinished construction has been included in the Guwahati metropolitan area in Schedule 1 of the Master Plan 2025.
What is your reply, madam, to this?
My lord takes up page number 10
Of,
of the writ petition, my lord.
no, of this affidavit. Have you filed any rejoinder?
No, rejoinder has not been filed. In fact, it was set of councils has changed. It was dismissed for default, my lord. It was restored the last year, my lord. If my lord takes up paragraph 17, my lord, we have stated that from the Assam Panchayat Amended Act 2011, it is apparent that the local body has ample power to deal with the development.
We are not dispute, there is no dispute with your proposition.
My lord.
But when GMDA says on affidavit, it is India, it is an area under their master plan. Can we have any other option? We are at the stage of final hearing, we hear them. It's not a motion. Has the Azara Gaon Panchayat said anything?
No, my lord.
Then,
Lord, service is coming.
if they do not say anything, Pamohi prima facie is there. Yes, you may be correct. Ramcharan is not mentioned, but is under Jalukbari.
My lord, averment to that effect has not been made that the Pamohi village in the Ramsarani Moja does not fall in the.
What else do you need? We were not concerned with Pamohi, Ramcharani or anything. Statements within paragraph to the effect that Ramcharani does not follow notified is so is not only correct. Department reports that Pamohi village in which the petition has unauthorized construction has been included. What else do you need? You have chosen not to even file a rejoinder to this.
In fact, my lord, pursuant to the notice issued by them, we also
Proceed.
communicated.
Master plan,
My lord takes up,
schedule 1. F. Let us see. F.
if my lord takes up page number 26, my lord, annexure 7.
F.
My lord, this has been written by the petitioner. Inviting your kind attention in the above that we so and so want to install a RMC plant at the land, tag number so and so situated at village Pamohi Moza Ramsarani. We have started the preliminary mobilization work after getting permission from Azara Gaon Panchayat along with getting NOC from government Gaonbura and member of Pamohi village. The initial work was stopped from your end and the notice was issued to us. We also applied and got permission from the revenue circle of Azara. With reference to the above, as we were not aware whether to take the permission from your office, we are now applying for permission for the said work. During your earlier discussion at your office on 26/9/2011, we came to know that the area is under the proposed scheme of the development for 2025. My lord, pursuant to this letter, my lord, the permission was also applied for, but my lord, they have not reverted.
Have you considered their permission?
No, my lord, page 7, my lord, or petition, my lord.
Yes.
Reply to that, my lord. That to the statement made in paragraph 10 to the repetition being the matter of record, the deponent does not admit anything which is contrary to and not borne out of the record. The statement made in this paragraph to the effect that the petitioner visited the office of the respondent number 1, where he intimated that NOC from the office of respondent number 1 was also required, being incorrect and denied by this deponent, my lord. In this context, the deponent stated that NOC for construction of from GMDA for development of land is prerequisite and not an additional requirement as we sought to be made out of by the petitioner.
My lord, in this regard, I may be given some time to obtain instructions from the petitioner, my lord.
2012 matter.
My lord, just a week's time, my lord.
Madam, it's a 2012 matter.
Just a-
11 years. Well, you could have considered the representation by a speaking order if giving bona fide, for argument's sake. If we presume that whatever has been stated by the petitioner is bona fide, they are not aware that this land is under is not under GMD. Or they were not aware that it's under GMD. And being aware, they have filed the application. And you have said that it's a prerequisite. Yes, we know. But under these circumstances, can you consider for a post facto, if it is not in accordance with law, you can reject and you can go for demolition. But if you think that it's something which could have been done if the application was filed in time, then you can still reconsider. Okay. Okay, day after tomorrow. Day after tomorrow for disposal.
My lord. Obliged.
No, let us pass the order. Heard MSN Upadhyay, General Counsel for the petitioner. Also heard MS Chutia, General Counsel for the GMDA.
On behalf of P. Nayak,
Chutia appeared in instruction of P. Nayak, Planet Standing Counsel GMDA. Full stop. The grievance of the petitioner is against a show cause notice and a demolition notice with regard to their ready mix plant
Yes, my lord.
issued by the GMDA. The edifice of challenge is that GMD does not have jurisdiction to initiate such action as the area in question falls under the Ajara Gaon Panchayat outside the purview of the GMDA. So the Learned Counsel, in this connection, has drawn the attention of this court. Hey, is it over? Drawn the attention of this court to Annexure A. Annexure A, the communication dated 17/9/2011 issued by the GMD, wherein the place of construction has been stated to be village Pamohi Musa Ramcharani. Full stop. The Learned Counsel submits that in the master plan, Ramcharani Musa, however, has not been mentioned. Full stop. On the other hand, MS Chutia, the Learned Counsel appearing for a GMD, has submitted that the area has submitted that the basis of challenge is fallacious in as much as Pamohi village comes under the master plan of the Guwahati of the GMDA and has been stated to be under the Jalukbari Musa. Full stop. He has further submitted that it is not the case of the petitioner, that there is another village, Pamohi, under Ramcharani Musa. Full stop. At this stage, MS Upadhyay, the Learned Counsel for the petitioner, has submitted that representations have been filed and are pending for consideration of the case of the petitioner for post approval, as the constructions were done bona fide under the belief that the area was under the Azara Gaon Panchayat, from which necessary permission was obtained. Full stop. Para. Let this matter be listed on after tomorrow on 21st and on 25th to enable the Learned Counsel for the parties to obtain instructions. Full stop. It is however made clear that on the next date, comma, the matter will be taken up for final disposal as the same is of the year 2012.
Obliged.
Maybe your lordship. This is a content matter, my lord. But this matter may be closed, my lord. This was regarding non-payment of contextual bill. And after issuance of the notice, my lord, it has been dismissed, my lord.
Okay, Part 3 SP. No, where are you? Part 3 SP does learned counsel for the petitioner. Whereas MS S. Kemprai, learned counsel has appeared for the respondents 5 and 6. Full stop. 3 does the learned counsel fairly submits that during the pendency of this case, comma, the order in question, namely order dated
16/7.
16/7/2015, passed in WPC 2215/2015 has been complied with, and the amount in question has been released. Full stop. Sarah, in view of the aforesaid submission, comma, this contempt petition is closed.
Obliged.
Yes,
I am-
no one.
Long time, multiple dates they have not appeared, madam. I am here because of the order dated 16/3, madam. Because former commissioner of the GMC was made a party. I think it was never sub, copy was never sub to him. Respond number 2.
None appears for the petitioner on call. Whereas Sri Bora as well as MS Das Burman has appeared for the respondents. Full stop. On the last two occasions also, namely 8/8/2022 and 16/3/2022, none has appeared for the petitioners. For para, in the interest of justice, list again on '21, day after tomorrow, on 26. 26 for 4. So it is however made clear that in case of further non-appearance by the petitioner, comma, this court would proceed in accordance with law.
May I please, your lordship, my lord, the contempt petition for violation of order at page 10, my lord. Page 10, my lord.
Pending since 17.
Yes, my lord. Since then, it has not been complied, my lord. Because the land has been allotted in favor of the petitioner. He has deposited the premium, my lord, 1,80,000 rupees, and thereafter Patta was to be issued. So there was a direction, my lord.
For consideration.
Yes, my lord.
What is your
Lordship, the affidavit filed by the Deputy Commissioner, Lordship, respondent number 4. Lordship, the affidavit in opposition, annexion number 1, Your Lordship, page 30.
13?
30. Lordship, you have found?
By 3-0,
Yes, your lordship. Lordship, there, your lordship, it is
3-0, there is no 3-0. Affidavit of opposition by whom?
by
6,
respondent number 4, your lordship.
not 6. By 4,
4.
4, yes, Pallav Losun, yes,
Yes, yes.
3-0.
3-0, your lordship. This is a report by the,
1 second, 1 second. 3-0 is internal.
did your lordship? Lordship has found?
One more. 4. 4, yes, 3-0.
This was filed on 28th of
Yes, yes.
January.
Yes, we have got. 3-0, yes.
May I read it, your lordship? This is a letter to the Commissioner Secretary to the Government of Assam Revenue Department, your lordship. With the reference to the subject cited above, I have the honor to inform you that the SDLSC has approved a settlement proposal of land measuring 18 lessas covered by Dag number such and such village Horumotoria under Beltola Moza with Mohammed Kamrul Islam Borbhuya, son of such and his wife such and such, held on 24/10/2005 wide resolution number 25. Accordingly, the proposal was sent to the government wide this office letter number such and such dated 12/1/2006. The government-wide letter under reference has ordered for the settlement of the aforesaid land in favor of the applicant for residential purpose, subject to payment of 40% of land value fixed at rupees 3 lakhs per katha. Accordingly, the applicant has deposited an amount of 1,08,000 as premium for the aforesaid scheduled white treasury challan such and such on 10/8/2006. Further, it is to be noted that as per the report of the Circle Officer, Dispur, Revenue Circle, wide letter under reference, there are 3 numbers of shops running over the plot of land. Also, the land over the Dag is reserved for Rajdhani. Moreover, there are some dwelling houses of the GAD department over the Dag, and as per records, no any settlement has been done till date over the Dag number 132 old /35 new of the said village and Moja. Report enclosed. As the said land is not used for solely residential purpose and the land is reserved for Rajdhani for the greater interest of public and to protect government land reserved for capital complex from further encroachment, earlier order may be set aside. It is to be mentioned that the matter is sub judice in the Honorable High Court, such and such. So basically, this is the issue, your lordship. And
Where is the order?
Order is at page 10, my lord. Page 10, my lord. The last paragraph is relevant, my lord.
Yes.
Last paragraph, my
In
lord.
view.
In view of the above and as agreed to by the parties, this petition is disposed of with a direction to the Deputy Commissioner to bring the matter of settlement of the aforesaid land to its logical end and pass an appropriate order hereon. In the event the Deputy Commissioner is of the view that the Patta is not to be issued to the petitioner, he shall pass a specific order thereon. If on the other hand, the Deputy Commissioner is of the view that the Patta is required to be issued to the petitioner under the process and under the law, he shall do the needful. So he has not done anything. If there is reason to
Lordship.
for rejection, he can pass order, my lord.
lordship,
But this order has to be complied with, my lord.
lordship, for this purpose, your lordship, the Deputy Commissioner has communicated to the Commissioner Secretary, and the Commissioner Secretary has given this communication that
Deputy
the
Commissioner
matter
has
has
to
been
comply with-
endorsed to the legal remembrancer judicial department for views as per approval, your lordship. And as per my telephonic instructions, the view has not been received yet, your lordship, from the judicial department. That's why the process is stalled.
Order of 2000.
See, madam, there are 2-3 things. First, this is a contempt pending since the year 2017.
Yes, sir.
Number 1. Number 2, The contempt had the order in question has given you all the liberty.
Yes, sir.
Only for consideration and past speaking orders. If you do not want to, if you have reasons not to issue the patta,
Yes, my lord.
you state the reasons. Otherwwise, you issue the patta. Your communication, inter-office communication indicates that there are certain reasons impending according to you, which is on the way from giving a patta to him.
Circle officer report also may be considered.
That is it. Now that is required to be given to the petitioner in the manner prescribed in law. Give him a hearing, pass the order.
Yes, my lord.
Now, for your internal communication, writing to the LR, then LR from SR, then DR, AR, we are not concerned with all those. This is something to do with your inter-office. Why should we be concerned? You take the approval of anybody, it's your wish, but we want compliance of the order. 2017, we are in 2023. And this letter you write in February 2023, does it make any sense?
The latest telephonic instructions that the reviews are, the view is not been received.
That is your headache. If you don't get the view from somebody, you take action. Or if you are, we do not even know if you are required to take the view. You're only directed to obtain. You consider the case of the petitioner. Consider pass appropriate orders. Before passing the order, if you get it, you want to have the approval of some legal authority, have it, your discretion. But we cannot wait from 17 to 2023.
We would appreciate the circle officer's report, Your Lordship, because there are.
Madam, are we
thousands of
saying
the
that you
JD
don't have
department.
reasons? What is the problem in communicating the same to the petitioner after giving him a hearing? Court has not said that you issue patta. Court has said that you consider the case, if you do not issue the patta, give reasons. At least he'll have an avenue for challenging if
Yes, my lord.
if the petitioner wishes. You cannot just hang him like this. Neither here nor there. Rajdhani complex shops are there. These may be good reasons. If he
Houses
comes
of
for
JD department.
adjudication or adjudicate, we may hold them to be good reasons, we may not have. But that's a different matter and speculation. But you have not even done that. Hearts free DP board are learned for the petitioner, who by means of this application has alleged violations, alleged non-compliance of the order dated 3/4/2017 passed by this court in WPC 1948/2017. Full stop. Para. The operative portion of the order reads as follows. Page 10, pencil mark, Rastraveki. Full stop. It is the case of the petitioner that though a period of 3 months was granted for compliance, till now, nothing has been informed to the petitioner. Full stop. On the other hand, MS and Bodoler appearing for whom?
For respond number 4, 5, and 6.
Appearing for the respondent numbers 4, 5, and 6 has submitted that affidavit has been filed. Affidavits in opposition have been filed
For
Full
all
stop.
the respond.
for all the respondents. Full stop. By specifically referring to the affidavit in opposition of the respondent number 4, the learned counsel has submitted that on 14/11/2022, a communication has been issued by the Deputy Commissioner Kamrup to the Department of Revenue, whereby the difficulties in grant of patta to the petitioner pursuant to the order of this court has been expressed which further remark that within inverted comma, earlier order may be set aside, full stop. Inverted close. The reference has also been made to the connected writ petition and the present contempt case. Full stop. The MS Borderline, the Learned Counsel, has also placed on record a communication dated 21/2/2023 issued by the Revenue Department to the Deputy Commissioner Kamrup within bracket M, informing that the matter is presently endorsed to the LR, Judicial Department for views. Full stop. Para. The communications referred to by MS Borderline are the inter-office communication and inter-office communication. Full stop. However, what is pertinent to be taken note of is the fact that the order which was passed in the year 2017 is yet to be complied with. Full stop. The direction contained in the order, as indicated above, was only for a consideration of the case of the petitioner in accordance with law. Full stop. This court had further given the liberty that in the event Patta is not to be issued to the petitioner, specific reasons are to be assigned. Full stop. This court is of the serious view that the matter has been dealt with in a most negligent manner, and the mere fact that the contempt petition is pending for the last about 5 years is demonstrative of the aforesaid conclusion. Full stop. Para. However, in the interest of justice, a final opportunity is granted to the respondents to pass appropriate orders. Full stop. Place this case on 8th of May 2023. Full stop. If it is made clear that no further adjournment would be granted, and in the event no orders are passed in terms of the direction of this court as mentioned, as referred above, this court will have no other option but to have personal appearance of all the respondents, in this case.
May I pray for some more time, Your Lord?
Not at all. We'll lessen the time. If you pray for time, we'll make it 2 days. 2017 and 2023. You think it's some kind of a joke? You come to this side and you'd feel the pinch. What was expected from you? Was there a direction to issue a Patta? That was not the direction.
Actually, in the meantime, new deputy commissioners and new circle officers were.
We are not too concerned with all those. Those always happen. Yes, next.
Deeply obliged.
Pleasure.
Yes, 41. DJ Mehdi. Who's there? 41. A. Sharma, U. Chaudhary, Fishery, P. Sharma. Mr. Dury, P. Sharma. 9 appears for the parties on call. 18 matters. On the last occasion also, there was no representation on behalf of the petitioner. Full stop. The matter is of the year 2018. Full stop. It appears that the petitioners have no further interest to prosecute this matter. Full stop. Accordingly, this writ petition stands dismissed for default.
I'm appearing on behalf of Mr. P. Sharma.
Non-appeasable petitioner, whereas Sri S. Dutta, Tenant Council has appeared on behalf of P. Sharma. Can you consider this? Huh? Yes.
In the morning, I have made mention in this.
Yes, yes.
So
In fact, we have complied. But
Are you aware of some compliance?
actually, I'm not.
You take instructions.
Yes, sir.
kindly may peruse the last of it.
No, he's praying for some time. A prayer for adjournment has been made on behalf of the petitioner. First of all, on the other hand, Sri P. Kakoti, Tenant Council, appearing for the respondents. The respondent has submitted that the order in question has been complied with. Full stop para. That this matter be listed after 2 weeks to enable the learned counsel for the petitioner to obtain instructions.
Much of the.
Yes, Mr. Dhar, what is this?
But pursuant to the order dated 26th of October 2022.
Yes, yes.
To take steps upon the respondent number 2 newly entailed.
You're taking steps?
I've taken steps on 3/11/2022 and the office note dated 4/11 reflects as notice has been issued. But the director of Fisheries
Anyone has appeared?
no.
Hmm. Name sure or not?
No, my lord. Name earlier, Mr. Bora was appearing for the earlier previous incumbent. P. Bora was appearing.
Your name is Joydeep.
Yes, ma'am.
What is your name? Joydeep Chemicals.
Jadip Chemicals. And the amount was very bigger amount. It was on grand total 1,35,613 only.
One organ, you know, one organ.
What is the order in question?
My lord, page 10 of the,
Tell us what is it?
this is the outstanding dues. The amount was rupees 1,35,613.
What was your defense?
My lord, my incumbent has retired long back.
No, that is understood. What was your defense that time?
Because my lord,
Just after receiving notice, he has retired, my lord.
Are you struck off from the area of parties?
Not yet, my lord.
So during your tenure, what did you do?
Yes.
Retirement, transfer,
Yes, my lord.
those will not be too much bothered. We want to know what did you do during your tenure? See, there is a note, there is a communication by the Director of Fisheries to the Registrar Contempt, which is not proper. This, we are not going to accept like this. Is the Registrar the authority? Either he has to come to the court in person or engage our counsel.
Yes, my lord.
What is the difficulty of a director? Is he a layman?
It's probably the present director, my lord.
16 November 2022.
Yes, my lord. For a present director, my lord.
Who is the present director?
NK
NK
Devnath, my lord.
Devnath. This is a contender number 2.
How can he write to the registry? Where is Mr. P. Sharma? Is he around today, Mr. Datta? Is he there or not? Is he there in the court today or not?
Yes, man. But if at present he is not.
Understood. Is he in the court or not?
Yeah, at present is.
Again, you are saying,
lord, my
at
lord.
present, we are not asking, is he in the
Yes,
court
yes.
today or not?
Yes, yes.
Can he come later?
Yes, my lord.
At 2 o'clock?
But my lord, it is not AFDC, my lord. It is Fishery Department.
Fish- Director of Fisheries.
Director of Fisheries, my lord.
He's sending consider AFDC only, my lord.
Oh, this is not FDC.
No, not AFDC, my lord.
He is the Director of Fisheries, Mr. Dury. The director is writing to the registrar contempt. He doesn't know the procedure. If he doesn't know, he can come to the court. We can make him sit in the court for 1 or 2 days.
Lordship, I humbly pray Lordship may grant 2 days time. I will bring it.
No, you utilize your good office. It's not the way. You see this? We are not on the contents.
Yes, Lordship.
But this is not the procedure.
Yes, Lordship. Let me correspond why this has crept into. So, Lordship, I will say definitely to done it.
And you may not be also agreeing to the contents. He says that an amount of 51,800 being the performance security has been returned to you.
Yes. That the earlier government also filed an affidavit. We said that we have not received that amount.
Part 3A, the Learned Counsel for the petitioner. Full stop. A perusal of the records reveals that a communication has been made. A communication dated 17/11/2022 has been made by the Director of Fisheries directly to the registrar within bracket contempt of this court. Full stop. There is no procedure of communicating with the registry on a matter, on a judicial matter, which is before this court for adjudication. And any views oblique stand has to be conveyed to the court by way of an affidavit, either directly or through a counsel. Full stop. At this stage, Kumar, B. Deuri, State Council, has prayed for some time to obtain necessary instructions. Full stop. List on on 8th of May.
Apply.
court number 30 of hearing courts.
Hearing kori aham.
Lordship, my senior Mr. P. N. Goswami is in the midst of a hearing. Maybe
What is this matter about?
Matter, my lord, is a suspension. I was placed under suspension, rule 6(2), my lord. And there is a, my lord, provisions of the law as well as several judgment, my lord. 90 days is the mandatory, my lord. For reviewing, they have to review within a period of 90 days, my lord.
Correct, correct.
The next, my lord, several judgment by way of affidavit, my lord. Lordship will see my additional
Now, what
affidavit.
is your case? There is no review.
There is no review.
90 days is over.
90 days is over, my lord. After 90 days, they might have done review. They have filed an affidavit. It reflects, my lord.
But in absence of Mr. Goswami, it will not be proper. We'll have it day after tomorrow or Tuesday.
Lordship fix on Tuesday, my
Tuesday.
Tuesday or 27, Lordship fix the other.
Tuesday, you'll have a hangover.
On 27, my lord.
We'll give one more day to you.
Lordship. 27.
27, not 27, 28. 28, madam. A prayer for adjournment has been made on behalf of Sri P. N. Goswami, learned counsel appearing for which department? Excise department.
Excise department.
Excise department. As requested, let this matter be listed on 28/4/28.
Obliged.
Mr. Mazumdar,
He too is in the midst of a hearing, my lord. He says he will come once he finishes it.
okay, let him,
Subject to the
Mr. Roy, let him come. Let him come, he was there.
Well, he may
And then
continue. My instructions are he may continue.
No, let him come, let him. come. It was called upon, but you were somewhere else, so we fixed it at 2 o'clock. Just wait for a while. Fix it.
Obliged.
The Lordship may kindly pass over for the guest since the age Amar Chaudhary is out of station.
Otherwise, it's complied, my lord.
Complied.
Order may be passed in presence of age Amar Chaudhary.
Are you aware that it's been complied with? Any instruction?
Yeah.
Then let him be there. A prayer for adjournment has been made on behalf of Sri A.H. M. R. Chaudhary, Senate counsel for the petitioner. However, on the other hand, Sri S. Dutta,
My senior colleague is appearing for respondent number 1, 2.
whereas Sri M. Nathan, senior counsel, as well as Sri S. Dutta, learned counsel, appearing for the respondents, submit that the order in question has been complied with. Para. Be that as it may, comma. Be that as it may, and in the interest of justice, the matter is adjourned to be listed on the 26th. 26th. Yes. Contempt.
May I please see my lordship?
Yes, yes.
My lordship, new incumbent is needed to be included, my lordship, in respect of sole respect.
We grant you how much time?
My lordship.
How much time?
Any.
Have you issued notice to the new
My
incumbent?
lordship,
Issued already.
already issued, my
And
lordship,
you can file your implement application by 2 weeks.
my lordship,
Your name is Mason,
my lordship,
A. Mason.
AMSN.
A. Mason, learned counsel for the petitioner submits that due to change of circumstances, comma, the new incumbent is required to be implemented as party respondent in this case. Stop. See accordingly placed for and is granted 2 weeks time.
Obliged, my lord.
Withdrawing.
Already the writ petition.
Three. R.K. Bhatra, learned counsel for the petitioner, submits that he would not like to pursue this contempt petition as there are certain developments. Full stop. Para, also heard Sri D. Goswami, learned counsel for all the respondents. All the respondents. Para, contempt petition accordingly stands closed.
Obliged.
May it please your lord. This is a contempt petition, lordship. The matter is relating to non-payment of contract.
Structured bills, yes.
My lord, may I pray for 2 weeks' time to file our affidavit?
19 matter.
Yes, lordship, we are appearing for the first.
Oh, it was not listed after 19.
Yes, lordship.
Why? Heard MS M. Doctor.
Lordship, may I pray for a copy of this contempt petition?
Heard MS M. Doctor, learned counsel for the petitioner. It appears that no notice of motion was issued on 1/10/2019, comma, the matter was not listed thereafter, full stop. Today, when the matter is listed, comma, Sri B. P. Kakoti has entered appearance for the respondent, who also pays for a copy of the petition, full stop. MS Datta, the learned counsel, undertakes to furnish a set of the petition by
Today's-
tomorrow. By tomorrow. List this case after 4 weeks to enable the respondent to file the affidavit.
Obliged.
Yes, madam.
Lordship, we would like to file a reply to the affidavit.
Okay. But that affidavit was filed in May 2021.
Lordship,
We're almost in May 2023, only 2 years.
Lordship, we have lost connection with the client. He had taken the affidavit, Lord.
The client has taken the affidavit.
Yes, Lordship.
It was not served upon you.
That has been served. Without serving, that is not possible.
How will they go to your client and serve a copy? Tell us.
Lordship,
possible? Huh?
must they have taken the affidavit? Yeah,
That is, you need to handle that.
Lordship, we grant.
It is given to you. Are you interested to pursue or not? Tell us.
Yes,
Yes. Are you in touch with the clients?
we have lost the,
Then how do you pursue? If the client doesn't want,
try to,
what is your name?
D Mohan,
B. Mohan.
D Mohan, the Lordship.
D. Mohanta.
D.
MS D. Mohanta, learned counsel appearing on instruction of Sri UK learned senior counsel for the petitioner submits that there is no instructions from the client. Full stop. See, however, prays for and is granted 2 weeks' time to seek instructions. List after 2 weeks.
Much obliged.
MSA Gan, CDC
Yes, madam.
is present for the respondents.
Please, your Lordship, due to some personal difficulties, Arjun has left the foot left.
You are a proxy counsel for all the councils today. Third adjournment you are seeking for on behalf of others. A prayer for adjournment has been made on behalf of MS.R. Chaudhary, learned counsel for the petitioner, full stop. Para MS.N. Bordler, learned standing counsel, revenue is present. Para, list after 2 weeks. Yes, Mr. Mehdi, what is this?
As per the last order, notice was issued and it
In
was served,
2021.
yeah, 2021 matter.
Hmm?
So,
Thereafter matter has not come.
Yes, yes.
24/11.
No.
Yes, sir. Anything? Instructions? Which department?
BTC is there.
BTC. Name shown or not? Names are shown.
Yes, in the morning, my lord, 2 matters were listed in the honorable single bench before the single bench of Justice Manish Chaudhary. They had
Similar.
appeared, yeah, they had
Similar.
already appeared.
Similar.
Yes, similar matters. So altogether like 9 work orders were there. So we had filed like different writ petitions because of the technicalities. So basically item number 51, 52, 53, they are all similar in nature.
You want your contractual bills?
Yes, it's a non-payment of admitted outstanding bill.
But where is the BTC council?
In the morning, they appeared in that particular 2 matters.
Just have a look if they're around, otherwise we'll have it in the next week.
Yeah, maybe in that particular court, the Honorable Justice had given 2 weeks of time.
Without in their absence, we're not going to pass.
Cannot
You
bring
try
back.
to bring them, otherwise you'll have it on Friday or Tuesday next.
Fine.
Just try to have a
Yes,
look,
yes,
they may be
fine.
somewhere
Yes,
around.
yes, yes.
Lordship, Lordship, in this matter, the respondents have not entered appearance. Lavazima order is there dated 16/11/2022.
Jorhat, I think they have a standing council. Jorhat, Mr. T.J. Mahanta.
At the time of filing, we had tried to contact, but then nobody had accepted notice.
No, we are not on the time of filing. At present, I think Jorhat has got a standing council. Jorhat
Development Authority.
Development Authority, or is it municipal board? Just try to get the information. 1 and 2. You have only 2 respondents.
Yes, my lord.
Your name, P. Agarwal.
P. Agarwal, my lord.
Heard MSP Agarwal, learned counsel for the petitioner, who has drawn the attention of this court to the order dated 16/11/2022, passed by the learned Lawzima court with regard to the service upon respond numbers 1 and 2. As per this, full stop, as per the said note, service may be deemed to be affected on the said respondents, full stop, para. Accordingly, the service is deemed to be complete on the said respondents, full stop. Since none has appeared in spite of service, in the interest of justice, matter is directed to be listed after 2 weeks to give an opportunity for the respondents to appear and contest. List on. You want a date?
My lord, it would be convenient. It is
List on 8th of May.
deeply obliged.
You in the meantime try to contact
Yes, my lord.
Mr. T.J. Mahanta.
If somebody is available, I'll find out and I'll serve the call.
Yes, next.
Deeply obliged.
Lordship, yeah, in this matter, your lordship, it seems to be the ex gratia amount, your lordship. Lordship, the same is being admitted, your lordship. It may close that with petition with an outer limit. At last para, your lordship. The proposal was sent.
Your name?
M. Rahman.
Hmm?
M. Rahman.
You're not on record. Are you on record? No.
On behalf of MS Lordship.
We'll have this recorded and we'll fix another date. Okay? 3. Theory, the Learned State Council submits that written instructions are available. Full stop. Since, however, the advocate on record, so none of the advocates on record are available, and only and the petition is represented by Sri M.U. Ahmed.
M. Rahman.
M. Rahman. Full stop, para. In the interest of justice, list after 2 weeks. Ask somebody to appear. We'll dispose this of.
The caste certificate, civil caste certificate.
Yes,
but-
Madhuri Patil.
Lord,
Madhuri Patil.
yes.
Yes, anything? Any instructions? We had issued notice on 22/3 after considering the additional FRB explaining the delay.
What to send by Mr. J. Hendrik, your lordship, so that's why I.
Yes, sir, tomorrow. Ask him to be
Yes,
present.
yes, yes.
Do Sri SP Roy, learned counsel for the petitioner is present. Come on. This court is informed that Sri J. Hendrik, learned state counsel, would address this court on behalf of the respondents. Full stop para. In the interest of justice, list on 21. Yes.
My name of my firm was removed from the GEM portal.
Yes, yes.
When
Yes.
we approached this honorable court,
No, no,
it appeared with the.
yes. Now,
Subsequently, my lord, as a counterblast measure,
so that will
debarred, they
yes.
were debarred.
Yes.
And now, my
Yes, what
lord,
is your
they
instruction?
were to receive the instruction, and before today, they were to do the needful so that the debarment order is removed or withdrawn.
Yes, my lord, here, my lord, that order, I have received the instruction, my lord. My lord, kindly come to my lord, the IA, my lord, 622, my lord, page 12. The impugn order, dated 24th of February, my lord.
Page
Page 12 of the IA, my lord.
Mhm.
I have discussed the issue, my lord, with the, my lord, that person, my lord, Colonel Kanwar, response number 7, my lord. Here, my lord, he wrote the letter to the GEM authority, office of the GEM, my lord.
Mm.
So, office of the GEM and all this, my lord, may come to page 13, my lord, last paragraph, my lord.
Mm.
Accordingly, in accordance with rule 151, so and so, third line, Suresh Kumar and all his allied associates, partner B ban revert, rejected to participate in the contextual activity in the core zone area.
Where are you reading 13?
13 last para 8.
8, according.
Accordingly.
Yes. In
Accordingly, in
accordance
accordance with rule so and so, procedure laid down by the Departmental Experience Community Authority has referred the farm, Messrs. Suresh Rai and all his allied associates, contractors so and so, be banned, oblique divert, technical rejected, to participate in the contextual activity in the core zone area. My lord, as per the instruction received from the, my lord, this response number 7, they have they have wrote to the GEM only. Nowadays, my lord, every tender has to come through GEM. Directly, no one can participate in a contextual activity. Now they have wrote to GEM that they be divert. So implementation agency is the GEM. Now, my lord, yes, my lord, on that day, my lord, on 31st, my lord, that instruction was not before me, though I filed on objection to the IA, my lord. My lord, on 17th of March, that my lord, first order was passed on 22nd of February. But technically, my lord, I have though informed that it was not in the website. It was published on 28th of February. Because of that, on 24th, that order was issued, 24th of February. But subsequently, on 17th of March, that person, response number 7, wrote to the GEM authority with a so in the portal, my lord, that order may be implied. Implementation of the order dated 22nd, that may be done. And subsequently on 7/4, last 7/4, GEM closed the incident after the expiry of suspension period. My lord, this is a printout from the portal. They have in the GEM portal. 5 incidents were raised against this petitioner farm, and they closed that incident on
7(4).
Hmm.
So my instruction is that they have made an objection and implementation agency is the JAM, and they have wrote to the JAM authority. Now, it is up to the JAM authority to allow the participate or not, and already that incidents were closed, on 7(4). And my colleague is appearing on behalf of JAM, response number 4.
Now, what is the implication of closing?
Objection was raised, 5 objection was raised. Incidents were
We
raised.
understood. Now you've closed the incidents.
Yes,
Now, what is
this
the
has been
net
raised
result?
now.
What will happen now?
As per my interpretation, as per the instruction of the number 7,
I am not on your interpretation. What is your instruction?
instruction is that at present there is nothing, my lord. They can participate, my lord. As the incidents were closed, my lord.
Mr. Singh, we record this.
No, my lord, the clarification is required, and there are 2 aspects, my lord. There were in total 4 incidents which were raised by GEM portal after receiving the complaints from the authority concerned, my lord.
Not 5
Then-
incidents.
Total 5.
Total
In
5.
one, that was no order was passed.
Yeah.
Out of 4, in 2 incidents, my lord, the suspension was for a period of 60 days, 2 months. And in the 3rd and 4th, it was for 90 days. So suspension has been revoked by the JAM because of the expiry of the period, not because of any action taken from their side. Number 1. Number 2, my lord, now coming back to the main issue, debarment. Kindly again read para 8, page 13, my lord.
Hmm.
Accordingly, in accordance with Rule 151,
Hmm.
para 2, para 3 of GFR 2017, procedure laid down. So there is a one rule, my lord, Rule 151, and there is a procedure. Department of Expenditure competent authority has debarred the firm, Mr. Suresh Kumar Rai, and all its allied associate contract be banned, debarred, rejected to participate in any contractual activity in the corpse zone being a habitual offender for a period of 2 years. Now, my learned brother is saying that it doesn't exist. But what the rule says, kindly see the rules, my lord. I am of the view, my lord, that my learned brother definitely has not gone through the rules.
Yes, my lord.
The entire rule has been reproduced, my lord, by the central government.
Hmm.
Now, my lord, the first page, your lordship will find I have marked the in pink color. The bidder shall not be debarred unless such bidder has been given a reasonable opportunity to represent against such debarment. So far, my case is concerned, my lord, no opportunity was ever given by the department before taking this drastic step. Now, kindly see the annexer part, which is the actual reproduction of the rules, guideline. Come to page number 4, my lord. H. The ministry department will maintain list of debarred firms which will also be displayed on its website. Now the department displays my name as a debarred firm. Even if my name is appearing in the GEM portal, so far my firm is concerned in the concerned ministry on its portal, I am shown as a blacklisted firm. Now kindly see, my lord, the next page, para 9. Similarly, government e-market can also debar. So there are 2 things. The department is debarring and the government e-market can also debar. Now government e-market is showing, but the department is still continuing with my blacklisting. Now what will happen, my lord? Thereafter kindly see clause 15. No contract of any kind whatsoever shall be placed on the debarred firm, including its allied firms by any ministry, subordinate offices, including Government of India, including autonomous body, after the issue of a debarment letter. So long this debarment order is in existence, my lord, even if I participate, I won't get any tender. Kindly see next 16 and 17. No contract of any kind whatsoever shall be placed to debarred firm, including its allied firm, after the issue of a debarment order by the ministry. Bid from only such firms shall be considered for placement of contract which are neither debarred on the date of opening of tender, nor debarred on the date of contract. And the ultimate is 17, my lord. If in case any debar firm has submitted the bid, the same will be ignored. Now, my lord, even if my name is appearing in the GEM portal, it is of no use, my lord, even if I participate, because of this rule 151, my bid will be not considered. So if this order, my lord, is not interfered with, I am not gaining anything. If my brother perhaps has not gone through it.
Is the name of the, does the name of the petitioner firm is still within the blacklisted?
My lord, as per
Entities.
instruction, my lord, as per instruction, my lord, they wrote to the GEM authority only, my lord. My lord, this.
No, what Mr. Singh
Yes, yes, my
is
lord. My lord,
trying to point out that the rules contemplate putting the name in the website of blacklisted thing, and that is still remaining.
That specific instruction is not before me.
Because that is what will matter.
My lord, yes.
If it is jam has closed, you said the department is not going to have any effect. As long as their name is in the list of blacklisted entities, they'll not be given any.
Even if my name appears, my lord, in GEM, and even if I participate, my lord, it can be
The
ignored.
legal prejudice will still be caused. What instructions have you taken?
My lord, yes, my lord, but my
No,
lord.
is it an effective withdrawal or only for the sake of it? Effective withdrawal will definitely require you to remove the name of the petitioner from the blacklisted entities. You take instructions, Tuesday we'll have.
My lord, may I bring to your notice the last order that was passed by this honorable court, second
Yes.
page,
In the IA.
in the IA, my lord. Second page, third para, Singh Learned Council, however, submit the restoration of the name of the applicant petitioner in the GEM portal would not be a compliance of the order, and the intent of this court by passing the order dated so and so, in spite of restoration, prejudice caused to the petitioner will still be there if the order dated 24/2/23 is not interfered with. Prima facie, the aforesaid order dated so and so does not appear to be in consonance with the order dated so and so passed by this court. Now, my lord, this still continues. My humble prayer is, my lord, kindly interfere. Otherwise, the prime time of my participation is already over. The March period is over, my lord. So, to some extent, the army authorities has achieved their target, my lord, of harassing me. They have already harassed.
Mr. Even for a moment, we are not saying that you cannot take action against him. If you have found misconduct, you can initiate a proceeding, but this is a blacklisting.
My lord, yes, my lord, may I kindly fix on my lord next, my lord. Maybe
Tuesday. Since you have taken an action after the order of 11/31/3, this appears to be on 7/4, isn't it?
Yes.
7/4 doesn't appear to be a complete order. It only takes part of one
Because
part,
of their, my lord,
and the
request,
main part is still there. Unless you remove the name from the blacklisted entities, there is no purpose will be served.
My lord,
instead of waiting for the instruction, my humble prayer is kindly interfere with that aspect.
No, no,
They are saying that they have done.
Mrs. Singh, if they do not do anything, will
No, my
definitely.
lord,
They have already complied with the order. Let them make full compliance.
my lord,
SK Singh, Learned Senior Counsel for the petitioner. Also heard Sri Parashar, the learned CGC, as well as MS Hazarika, P. Hazarika for the response number 4, the GEM, E to Horo. Sri Parashar has produced before this court a written note.
it is
As
print
per
out
which,
from the website, my lord.
huh?
It is a print out from the website.
A print from containing certain contents from the website, as per which the incidents pertaining to this case appear to have been closed. Full stop. The senior counsel for the petitioner, however, submits that simply by removing the name, simply by a clearance by the GEM will not serve the purpose unless the name of the petitioner is removed from the list of blacklisted entities by the army authorities. Full stop para. On this, Sri Parashar submits that he may be given some time to obtain instructions regarding the steps taken towards full compliance of the order of this court. Full stop. Full stop. List, Tuesday,
Or maybe on
Tuesday you're here,
26.
On Wednesday.
Wednesday.
26, my lord, yes.
List on, okay, you'll be present, Mr. Singh?
My lord.
List on, as agreed, as agreed to by the parties, list on, 20, 26. You can take this back.
My lord.
I hate it, listen. I hate it. Eight. 68.
May I please, your lordship, kindly adjourn the matter for the day, my lord.
You're from whom? Mondal?
Yes, my lord.
17 matter difficult. Why was it for orders?
Madam, actually that should be for hearing, my lord. The rule was issued earlier and ready for hearing, my lord. Against the order of Board of Revenue regarding correction of record.
Okay.
So matter was placed after 2 weeks, my lord. The hearing.
Though this matter has been listed for orders, comma. The same can be taken up for disposal. First off, it is seen that on 29/3/2017, rule was issued and the records were called for from the learned Assam Board of Revenue. Full stop. Para. Place for hearing after 2 weeks. Interim order passed earlier to continue till the disposal of this litigation.
Okay.
69. Sharma?
May I please, your lordship?
Yes, yes.
Lordship, here I am appearing for respondent number 5. Lordship, I have received instructions today in the morning that a sealing proposal was sent in regards to the petitioner's amount that has to be refunded. My lord, but that amount has not been passed yet. Lordship, I am seeking 1 week's time so that I can get an up-to-date instruction regarding a sealing proposal.
The pending is long.
Yes, Lordship, Lordship, I am trying to expedite the process only, but I am.
Take immediate instructions.
Lordship, 7 days time I am asking for, Lordship. One week's time.
Sri Sharma, learned counsel for the petitioner. Para. Sri Chalia, learned counsel appearing for the respondent number
5.
5. However, submits that the sealing proposal has been made and only the fund position is to be ascertained from the finance department.
Yes, Lordship, it has been passed, but we don't know the exact status. That is what
only the fund position is required to be ascertained. Full stop. He accordingly prays for and is granted 10 days time.
Lordship.
We'll fix a date. 10 days time. List on 3rd of May.
Lordship.
May I please, your lord. This matter pertains to tenure of the boards, my lord, that I have received the copy of the affidavit also. They have relied in terms of the Supreme Court and full court matter. Now, our tenure is going to be complete tomorrow. Now, issue is that, my lord, whether tenure can be extended or not because of the stay order bypassed by this node. And in Supreme Court's decisions, my lord, that was whether from the date of approval it will be counted or from the date of election it will be counted. Slightly, to my understanding, slightly possibly different. Whether that 1 year loss, my lord, that can be extended or not, that is my take.
Yes, you can argue if you want. If you want this court to pass an order accepting your views, you have to substantiate your views.
So for
how do you compare your case with a case, normal case of an for lease, a statutory lease or other lease? This is a case where you had occupied the chair on the mandate of the people. That mandate was for a particular period.
5 years.
Now, once the period is over, the mandate comes to an end.
To that my lord, point of view, my lord.
The people, they had elected you for 5 years.
5 years.
After that, unless the people want,
That is
whether as a right you can. If the department allows you to continue, it's a different matter.
that is
But as of right, can you continue? That is the question where,
that part. That
if
was
you can, address and if you can convince us,
my another problem is that, my lord, I would be disqualified because of, my lord,
that part we can take care of.
that part, my lord, at least, my lord.
Mr. Kaludar. Disqualification part.
Yes.
We can, we have done in other cases,
My lord.
if we can show their bona fide. And we can make some observation that they'll make an application which should be considered.
But those cases are distinguishable. Because normally, my lord, there is a legal fiction, automatic dissolution. So, my lord, this is mandatory. Your lordship taking into account, my lord, the COVID situation. And in terms of the division bench, division bench, my lord, has said that since the failure cannot be attributed to them, so, my lord, disqualification will not apply. But here is a case totally different. Now they are aware that tomorrow, my lord, the board is going to, my lord, going to expire. So they ought to have approached this court, my lord, earlier, so that if the verdict goes against them, my lord, so that they
Now,
can
what
make.
is the main reason of their seeking extension?
My lord, in between there was some, my lord, judicial proceeding.
That is it.
Yes.
But can they be fall be attributed to them?
No, I'm not on that. What I'm on.
Because none is required to suffer by orders of the court.
Yes.
That is the law.
My lord, what I'm trying to say regarding disqualification part, my lord, they could have come earlier. And if the verdict, my lord, had gone against them, then they could have, my lord, held the election. Then in that case, my lord, the disqualification would not have arisen. But they have come at the 11th hour. Now there is no time also, my lord, to hold the election because the board is expiring tomorrow. And whether your lordships, my lord, will apply the, my lord, orders passed in those cases under 130 capital A. This is not a case under 130A. So this is my submission. If your lordship, my lord, directs the petitioners to approach the department, perhaps, my lord, they will get relief or not, I don't know. That can be done, my lord.
That at best, they will do that.
Yes,
Nothing more than
otherwise, yes, understand. Same case, my lord. I have filed affidavit there.
I will argue the matter, I will satisfy your lordship. It may be come upon admission, I will argue it. Completely different.
But if tomorrow the elections are held, same society.
Is it different?
Different society. Different society.
Your term is not expiring tomorrow.
Expire, one man is
Expire,
running.
but election was stayed by this one. Because my approval was not given, election was not approved because of this court order. Already 2 years left. So there is a clear interim order that suspended the approval. So we come up on admission and they have filed already affidavit filed.
Look, in fact, the affidavit filed in that case, his case, my lord, I have already stated that the issue, my lord, is covered, my lord, under a Supreme Court judgment, and there are two decisions I have found. This honorable court has relied on the Supreme Court judgment because the statutory prescription is very clear, counting of 5 years from the date of election, and this is pursuant to, my lord, the constitutional mandate under 243 ZK.
Yes, but
The corresponding, my lord, statutory prescription.
If you want to argue,
Section 31 also clarified like 5 years, for 5 years.
what is, there is an interim order. What?
Yes.
In his case, there is an interim order.
And Mr.
No, tomorrow the board will be dissolved in that case.
My case was filed earlier.
He wants to argue, you'll have to give him an opportunity of addressing the court.
Hello?
He says that he wants to address the court on
Yes,
the.
yes. So far as he is concerned, he may address it, my lord. I have no problem.
When do you want?
After a week, any date.
There is no interim order. There is.
In his case, there is an interim order that no election will be held. Now the one man is running, but the one man, my lord, will run only up to period of 90 days in terms of 41(6). So lordship will. Yes.
Yours is 6249. Or one.
6249, yes, my lord. 6249.
You should write in 6249. 3 A.U. Ahmed, learned counsel for the petitioners. Submits that the matter be taken up for admission hearing. Full stop. 3 Talukdar, S.K. Talukdar, understanding counsel, Cooperation Department. However, submits that though no affidavit in opposition has been filed in this case.
I have filed, they have not filed reply.
In this case, you have filed.
Yes, yes.
When?
This 6249 I have filed.
6249 you have filed.
Yes, my lord. I filed on 33/23, 30th of March, my lord. Page from page 75, your lordship will see continuation, my lord, running page.
70?
75, running page, my lord.
In which case?
6249, my lord.
6249, 22.
30th of March 23. 71. 71, no?
Oh, yes, yes.
71, my lord.
By as per number 5.
My lord, 5.
From 58.
My lord.
You have not filed in the other one.
My lord, in fact, I submitted that the stand taken by
Yes,
the
yes, no,
department
no.
will
This
cover that case.
order we wanted to pass in the other one.
Yes,
Actually. Okay. Then instead of passing orders in Mr. Hawk's petition, we'll have it together.
Yes, I don't have any objection, my lord.
Otherwise also doesn't make any difference.
Yes.
You write in 6249 লিখছে নাকি? সবটা কি করলো লাস্ট এসকে হাবো না লাগে হাবো না দিবা এসকে Allotment understanding concept cooperation department submits that affidavit in opposition has been filed on 7/2/2023, which however has not been replied to. Full stop. He further submits that since a similar point of law is involved in the connected petition WPC 1504/2023, the affidavit in opposition filed in this case may also be taken into consideration while deciding WPC 1504/2023. Full stop. Para. We'll have it on a hearing date then.
Section they make.
List on, we'll have it on 27th, earliest, Thursday.
Oh, no, that cannot be.
Any action taken in the meantime shall be subject to the outcome of this appeal. Mr. Andy, we have one case of yours. Asil na hai to eta? Eta to BTC asil. You are for BTC?
Yes, lordship. Lordship, in this 51 to 53 item, lordship, with regard to the non-payment of contractual bill, lordship, an audit has been done by an independent body of all the departments of BTC, and there they have submitted a report, and on the where they have finalized who has got done genuine work, and on the basis of that report and applying temporarily, lordship, a list is in the process of preparation, lordship. Lordship may take it up after 3 weeks.
But are his cases taken into consideration?
Yes, lordship, taken into consideration whether that has been approved or not. That
R3W or Medhi, current concept for the petitioner. Petitioner, very deeper. Same order, a separate number. Also has to be Chaudhary, understanding concept BTC. Full stop. Para. The matter is, these writ petitions pertains to the issue of contractual bills. Full stop. It is submitted on behalf of the petitioners that since a separate work orders are involved, separate writ petitions have been filed. Full stop. Para. The Chaudhary, the Learned Standing Council BTC, however, submits that in terms of a notification, a committee is examining the matter. Examining matters relating to claim from the council on the issue of works done. The committee is also looking into the validity of such claims and the validity and admissibility of such claims. Full stop. Para. Not para. It is submitted that the case of the petitioners are also likely to be included in the said examination by the committee. Full stop. He submits that since the work of the committee is in progress, some time may be granted to get the updated instructions regarding the steps taken towards the claim of the petitioner. Full stop. Para. List after
3 weeks.
List after 3 weeks.
Obliged. Hello.
Handy or yes. Handy. 60. No, no, I don't know.
Dilip Mazumdar, no? He Mazumdar, my lord, I did not see him today. So whether
No, he was there. MS S. Sharma had said that, in fact, had suggested that matter should be started by the time he'll come. It was called upon in the first half, but Mr. Roy was not there at that time. So to give him the opportunity of fix now, second half he is there, but Mr. Mazumdar is not there. But Mazumdar in the morning had prayed for some time. We said we are not going to go into other issues. We are going to continue with the hearing.
so, one.
This will be taken next week because this matter will take time, sufficient time.
Okay. 27th of February. 27th.
Lordship,
Thursday.
I will inform.
Please inform me. Ask him to be here. 15 matter doesn't look good.
Lordship.
No, this- Though this matter was fixed today, the Learned Counsel for both the parties could not be present at the same time. And therefore, in the interest of justice, the matter is adjourned and is directed to be listed for admission hearing on 27/4/2023.
Obliged.